Is that better? Okay, thank you. Before we move on to anything else, I understand from the hotel that there is no fire alarm planned for today, so in the event the alarm goes off, it is the real thing, and we go out down the stairs, out the front door, and gather to the left of the gorilla. My name is Jennifer Wallace, and I'm a Chartered Town Planner and the Inspector appointed by the Secretary of State to conduct this hearing and determine this appeal. The appeal is by Mr Nigel Hobbs and arises from the decision of Wealdon District Council to refuse planning permission for the development described as outline planning application proposing the development of land at Golden Jubilee Way for the erection of up to 250 dwellings with the creation of new roundabout access on Golden Jubilee Way and new pedestrian and cycle linkages at land east of Golden Jubilee Way, Westham. This hearing will be a structured discussion, which I shall lead based on an agreed agenda. The purpose is to enable all of you to put forward your points of view and to help me get the information I need to make my decision. Before we start the discussion, there are a number of formalities I need to complete. Firstly, can I take the names of those who wish to speak and their interest in the case, starting with the appellant?
Is that better? Yeah? So I'm Tom Butler, civil engineer at Hop Consulting. We completed the flood risk assessment that supported the scheme.
Morning, Simon Myrams from Rapport. Been working with Hop on the flood risk.
Morning, I'm Andy Stevens of ASP, planning consultant for the appellant.
Good morning, I'm Shannon, planning consultant from ASP on behalf of the appellant.
Thank you, and turning to... Sorry. And the gentleman next to you. Is it likely that, as I'm aware, I don't think you're able to hear the people in front speaking there, is it likely either of the three, sorry? Would it be helpful then, if, since it's just the two of you, if you moved to that table there, is that all right with everyone? Sorry? Yep, absolutely. If either of the three of you are likely to speak, will we be able to play musical chairs? Thank you all very much. And for the council?
I'm Kirsten Roberts. I'm the Senior Planning Officer for the decision.
Charlie Cooper from Ardent Consulting Engineers. I've been looking at the flood risk on behalf of Wealdon.
Good morning. Declan Redman, Assistant Team Leader for the Majors and Strategic Sites team.
Thank you. And do either of you wish to speak today? That if you change your mind at any point, please just attract my attention. That's not a problem. Is anyone from the press present? And does anyone intend to film or record the event? Okay, does anyone have an issue with appearing on the live stream or being on YouTube for 6 months? Right, okay, thank you. Turning on to the timing for the day. Given the detailed nature of the flood risk issue, what I'm actually proposing to do is slightly alter the order of discussion of the main issues and move up the affordable and self-building custom housing to discuss after the suitability of location, then take a very brief comfort break after that. In terms of the flood risk, obviously there is an awful lot of information to be gone through here. What I would hope is that we could get through the questioning on that prior to lunchtime, but I may return to this issue after lunchtime once I have digested what everyone has to say. I would hope to be finished by 5 o'clock, and if necessary, we can take another short break in the afternoon. Notwithstanding, anyone needs a break at any point, please attract my attention. I have received copies of the Council's letters of notification of 21st January, 31st March and 1st of April, advising interested parties of the appeal and of the arrangements for the hearing. I am satisfied the hearing can proceed on this basis. Any comments from anyone? Okay. I also have copies of the representations made in response to the planning application consultation and the appeal notification. Can I confirm the parties have had the opportunity to view these? And I will take those representations into account when reaching my decision. I have been to visit the appeal site using the public right-of-way on the site and from a few other locations in the surrounding area. However, I will be making a further site inspection later. Following my pre-hearing note, both main parties were satisfied that that visit in principle could take place on an unaccompanied basis following the hearing. Does that remain everyone's view? I'm just about to come on to that, Mr. Banner. If anyone changes their mind as to whether or not that should be accompanied, we can discuss that at the end of the hearing. If there are locations that the parties feel I should go to view, would you be able to prepare those, discuss with each other if necessary, and if that could be available at the end of the hearing, that would be very helpful. Yes, thank you. In the event that the site visit is to be accompanied, it does remain my intention to close the hearing here to ensure that interested parties can fully participate, and because conducting and recording discussions on site can be challenging. In the event that it is an accompanied site visit, it is to enable me to see the site. There will be no discussion of the cases. Therefore, it's important anything you have to say is said before we leave today. As part of the process today, we will have a discussion about what conditions would be appropriate were I to allow the appeal. This is a standard procedure. It does not indicate I have made up my mind on the case, nor will the discussion affect the Council's position in relation to the proposal. The Council has submitted suggested conditions as part of their appeal statement. Are there any amendments to this or updates I should be aware of? Nope. There is also a planning obligation before me with which both parties have indicated they agree. We will return to both of these matters later in the agenda. But in the interim, could I please ask the Council, could a copy of the definitive map be submitted to the case officer showing the public rights of way that cross the appeal site and also the Westham 22 public right of way that's referred to in the obligation? I have an outline and some supplemental details of an application of costs before me on behalf of the appellant. Do you intend to expand on this towards the end of the hearing?
We intend to reply to, we got a very lengthy document from the council 2 days ago, some months after the documents to which it responds. I could reply to that orally, but it may help you if we put something in writing by the end of the week. Obviously, it came in at a very late hour. So I'm in your hands, madam, as to how you prefer to deal with that.
Has Council got any views on the appellant's response coming in writing? Yeah, I agree. That's a sensible approach, given the amount we have to discuss today. We will discuss sensible deadlines at the end of the hearing once we've seen if there's anything else. Thank you. Does the council intend to submit any application for costs? Thank you. All documents and evidence should already have been provided, and I am not inviting anything new, but is there anything new I need to be aware of? Thank you. In response to the pre-hearing note, I have had comments from both parties with respect to what would be the approved plans in the event that I were minded to allow the appeal. And it seems that there is not agreement on precisely the status of those plans, and I'd like some clarity on that to inform the discussion today. So, I mean, firstly, the red line plan is the red line plan, and that's not in contention. Firstly, on the illustrative master plan, can I firstly ask, is the arrangement of the internal access roads shown on this drawing to be considered as part of access, or is that an indicative part of layout?
That's an indicative part of the layout, ma'am.
And can I ask the appellant why they think the indicative master plan should form part of the approved plans?
When I have to say, when we included that in the list, it was to gauge the council's reaction, and having seen the council's reaction, we now agree with the council and that it shouldn't be in the list. It was speculative, I suppose.
That's helpful. Any comments from the council? Thank you. So the illustrative master plan is going to do what it says in the title. Thank you. Moving on to the roundabout drawing. I'm going to call them what they show rather than the extremely long titles. Can I ask the council, the application has access to be considered at this stage, and the red line plan does appear to have been drawn to include this. Why do you consider it shouldn't be an approved plan?
The workings for the final design will be agreed via the Section 278 agreement with the Highways Authority, and so it's not a definitive plan at this stage, although the access and the location is where it is going to be. It's just that the works proposed might not actually be completed in that manner.
And comments from the appellant?
I think, ma'am, the access, as you say, is part of the planning application, and it seems to me that those plans do need to be included. I think as far as the council's point is concerned, there's a similar discussion to be had later in response to one of the conditions that they're suggesting as to the highway works and the definition of the highway works. But as far as the access is concerned, it's clearly part of the application.
Just in the council's experience, how often does the Section 278, I mean, you know, Section 278 follows planning permissions everywhere, every day. How often does that process result in a change that is far away from what is actually shown on the planning application plans?
I wouldn't know, to be honest. And if you're happy to include it, then the council will accept your decision, of course.
Anything else from the appellant?
In this case, there were some very lengthy and detailed discussions with the Highway Authority and Highways England about the access to the site. And that suggests to me that there really isn't going to be probably any change, except perhaps in matters of detail in the Section 278.
Thank you. And moving on to the off-site highway improvement works plan, these do not appear to be within the red line of the site and are some distance, short distance from it. Is that something that, well, I don't see that could form an approved plan as it's not within the red line.
I think you may be right in that. I alluded to the discussion that we need to have later about the condition relating to those, so that plan can be excluded.
Council in agreement with that, I assume. Thank you. I have been provided with a signed statement of common ground which sets out areas of agreement and specific areas of disagreement. It is agreed that the council cannot demonstrate a 5-year supply of housing land at this time, and paragraph 11D of the framework is therefore engaged, so I am not proposing any discussion of housing land supply. An agenda was circulated yesterday and then a second agenda, correcting my mistakes, thank you very much. Can I confirm everyone has seen both of those? The agenda sets out what I regard to be the main issues, namely whether the site is a suitable location for the development with regard to the locational policies of the development plan and the Wellington Levels recreation policy area, whether the proposed development would be at an unacceptable risk of flooding, and whether the proposal makes appropriate provision for affordable housing and self-build and custom housing. In addition, I have questions arising from comments made by interested parties and also questions in relation to the requirements of the habitats regulations that I will come on to later. As a result of the discussion today, the main issues may change in my decision. Does anyone have any comments to make on the main issues, starting with the appellant and the council? Thank you. During the discussion, I will invite contributions from each side. If you wish to make a point or feel I'm moving on before I've said all you want to say, please tell me. I have read all the written statements, so while there is no need to repeat material, given the nature of particularly the flood risk evidence, it will be very, very helpful and welcomed if you can specifically point me to paragraphs in the documentation. As this is a hearing, there will be no formal presentation of cases or cross-examination unless I specifically agree to it. So turning to the first item, are there any other procedural issues anyone would like to raise at this point? Thank you. So turning on to appropriate location. Starting with the council. Policy PW5 is of quite some age. Have there been any changes in the area since 1998 when the policy was adopted that would affect the open character of the Wellington Levels recreation policy area?
Not in that particular location, although surrounding the area you have got residential development that has been allowed over that period of time in excess of probably 1,000 houses. But that particular stretch, I would say there's been very little change in that time.
Turning to the appellant.
The local plan refers or shows the indicative line of what is now Golden Jubilee Way, which didn't exist at the time, and does have quite a significant effect on the appearance of the area now that it's constructed.
There is obviously also, Madam, the policy change in climate due to the 5-year supply situation. The most important policies are out of date and must therefore carry less weight. I mean, just to cut through this, our understanding is that the council's position now, at least, having regard to the statement of common ground, is were it not for the flood issue, there would be no, in principle, opposition to the residential development of this site, bearing in mind the absence of a landscape objection, the acceptance of sustainability, and bearing in mind the housing supply situation. Whether that's by virtue of the MPPF as opposed to by virtue of development plan is an important nuance, but ultimately the end destination, we understand, is that the only in principle objection the council advances now is the flood risk one. But we may have misunderstood it.
Could I perhaps assist just pointing to two sentences. One is paragraph 7.6 in the Statement of Common Ground. It's quite short, so I'll read it out. It is agreed that the site is in a sustainable location in terms of accessibility, and there is no transport or access reason for refusal in relation to the application. So that's an agreed position. And for further clarification, the first sentence of the 5th paragraph of reason for refusal number 1 is where the council states that the location of the development is inappropriate merely for the reason of flooding.
As we read reason 1, it's the flooding issue that effectively disengages the tilted balance, brings into play 11D1, which I'd like to make some representations to you about later under the flood risk heading, and effectively then means that what would otherwise be the, for us, successful application of the tilted balance doesn't come into pass because of 11D1. So if flooding was taken out of the equation, the outcome would be different. That's our reading of the first reason for refusal. And it'd be quite surprising in the current policy climate if the council were saying that a site which is sustainable, doesn't have a landscape objection, etc., is objectionable in principle on pure policy grounds.
And turning to the council, is it accurate to say that you have no objection in principle to the proposal?
In principle to the proposal, we don't have, for residential development, we have no objection. But in relation to the flood risk and therefore the associated quantum of development and the safety of the site, if the development were to be set out as it is in the indicative layout, we would have concern, objection. So yes, in principle, I accept the position of the appellant, but we would caveat that with the fact that we don't believe that 250 units can be delivered safely for the lifetime of the development.
So, Madam, if I may, I mean, it may follow, or it does follow from that, that the second bullet in your agenda is essentially determinative of the dispute as between the two parties.
It's nice when the questions ask themselves, Mr. Banner. So the first paragraph of your first reason for refusal, which sets out the development boundaries, the policy area, is that actually part of your reason for refusal in that case? Or is it simply because of the flood risk it fails?
In two parts. It fails because of the flood risk and therefore the location as set out is unsustainable. But we accept that there is potentially a scheme that could come forward that wouldn't have an adverse impact, even though it is outside the development boundary and would be classed technically by, albeit our saved policies that Mr. Banner believes are out of date, but I would dispute probably later, that we would accept development in that location subject to the flood risk being resolved.
Okay, thank you very much. Just one final point on this. Are the council satisfied, given that policy PW5 refers to walking and cycling routes throughout the area, are you satisfied that's a matter that could be suitably addressed at the reserved matters stage as part of the layout? And I accept this is, in light of the statement of common ground, I accept that the questions about affordable housing and self-built housing are possibly somewhat moot. just for the avoidance of doubt, can the council confirm that once the planning, were there to be a completed planning obligation, the third reason for refusal would be overcome? Okay, given the speed that we've got through everything, we will not be taking a comfort break before we move on to flood risk. Now, this is an issue which appears to have been subject to discussions for, I make it 4 years now from the timelines before me, and there is a substantial amount of information before me. Consequently, I want to go through this in detail, and I am going to be asking very, very, very simple questions, just so there is absolutely no doubt at all, because I'm aware that in addition to the time, things have changed. So again, as I said earlier, if you can point me to the specific bits of your evidence, that will be very helpful.
Based on experience of other flood risk, a number of other flood risk cases, including one that's been before court recently, could I invite you to consider us looking at the policy context first? Because there does, in our view, seem to be a bit of a elision of the relevant policies on the council side, and I think it would be very helpful to you to understand how this fits in both to the MPPF provisions on flood risk and paragraph 11D1. It's our view, it'd be very helpful to do that at the outset, but it's entirely up to you, of course.
Has the council any objection to starting with policy?
No.
In that case,
Thank you.
set
Thank you,
out
Madam. I don't want to hijack in any way the event, but we've given a lot of thought to this. Madam, it's probably worth having the framework up if you probably always cite it from the backs of our eyelids, but could we please start on page 50, which is the same in PDF and hard copy. And when you have that, Madam,
Yep.
So there are three main steps in relation to flood risk policy under the framework, and so it's important to understand the different functions they play. So firstly, there is the sequential test, which is set out at paragraphs 172 to 176. That's obviously no longer an issue as between us, but it's of some relevance when one looks at the officer report. Secondly, then there's the exception test at paragraph 178. One of the requirements is for the development to be safe for its lifetime, C178B. And for that purpose, one has regard to what's called the, forgive me if I'm telling you what you're in, the design storm event, the design flood risk event, which is something that's then modelled. And then at 181C, which is just over the page on 52, there's a requirement for any residual risk to be safely managed. And the word managed is important, as is residual risk. So whereas for the design event, one is seeking to avoid the residual risk, which is something less likely than the design storm event. It's a sort of sensitivity test. One is looking not to avoid, but to manage. And there does seem to us to be a degree of elision in the council's case as to, are they saying this scheme fails the exception test, or, as we think they are saying on analysis, we pass the exception test, but residual risk is not safely managed. And see, for example, paragraphs, I don't think we need to go, but 5.5 and 6.4 of the Ardent report, Appendix 10 of the Council Statement of Case.
Sorry, which paragraph references?
Paragraphs 5.5 and 6.4. And that's important when one comes to look at, and could I just invite you, Madam, to take up the Yatton decision, which is appended to the HOP flood risk statement of case, which was an inquiry decision after a long and very vigorously contested inquiry, which Mr. Myrams and I have some familiarity with. And could you please, within that, go to page 17 of the document? I don't know whether it's 17 of the PDF, but 17 of the printed page numbers, paragraph 75 and following of the decision of Inspector Prentice.
Mm-hmm.
And you see then there's discussion of what is the design event. And for the design event, for exception test purposes, you see at 77 on what seems to be the critical issue between us and the council, which is, do you imagine the flood defences aren't there? No prospect of the existing defences being removed. Consequently, for the purpose of this site-specific FRA, it's reasonable to take the defended scenario as the design event, and that was on EA advice too. Then there's a second section at 18, page 18, paragraph 82 and following, managing residual risk. And you'll see there how the Inspector Prentice saw those in a way that I suggest one should see them as separate issues. There's avoiding unacceptable risk in the design event and managing the less likely residual risk. And you see there over the page again at 19, paragraph 89, the council's concern is there wouldn't be safe access in an undefended scenario. And 91, the last couple of sentences, the points discussed above in relation to design event managing residual risk are applicable to the issue of safe access. I regard the defended scenario as the design event, in which case there would be safe access. The undefended scenario is a sensitivity test, which helps to assess residual risk. So it's a factor, and only a factor, at the residual stage, not at the exception test stage. And given one at the residual stage is looking about managing rather than avoiding, the flood management plan was an appropriate way of managing that less likely residual risk. And I hope it's clear from that sort of potted outline of the different steps why the distinction is of potentially quite profound importance to the debate between us. Lastly, Madam, for the purposes of the sort of policy outline, one has to go back to the MPPF and paragraph 11. And paragraph 11D1 was changed in the last iteration because clear reason for refusal became strong reason for refusal. So the application of policies that protect areas or assets particularly important provides a strong reason for refusing. And that's something that in the context of flood risk decision-making was dealt with by Inspector Owen Woodwards in the Faversham decision, which again you have appended to our main statement of case. And could I invite you, Madam, to turn that up at page 20, paragraph 101. And at 101 you see a sentence between footnote 7.
Can you point me to where that decision is?
Yes,
please?
it's one of the appendices or accompanying documents to our statement of case. It's Appendix 1 in the PDF. I'm not sure from memory whether it's actually within our statement of case or a separate PDF. Let me just have a look. It's within it, certainly the version I've got, Madam. So if you've got our statement of case, if you go to PDF page 32, you should have the relevant passage.
Yes,
Thank you.
finally.
So,
Apologies for that,
that's
everyone.
Okay. There are other passages in this decision that say the same thing, but this is the pithiest quote. And Madam, you'll see their reference to footnote 7. And then you see in the third sentence a strong reason for refusal, and there's an emphasis on that new language used in the latest version of the framework. A strong reason based on flooding must, to my mind, go beyond mere technical conflicts, even if they're important. There must be substantive risks and harms that go beyond policy. And although that was a sequential test case, the inspector is expressing this in general terms as a strong reason for refusal based on flooding. And of course, 11D1 must operate the same in every context. And so, Madam, the reason I provide that outline to you, and it's something I've talked with Mr. Barnes and Mr. Butler, so I'm speaking for the three of us, if you like, for them, and they'll jump up and down if I'm saying anything wrong, Madam, is that I do suggest it's important to seek clarification from the Council that as to whether its case is an exception test one or a residual risk one, or both, bearing in mind the different analysis at both stages, as I've shown you, and that it's important also for the Council to demonstrate how it is that in the context of a case that they make reliant upon assuming that the flood defences no longer exist, how that is a substantive risk and harm that goes beyond a mere technical issue in the way that Owen Woodward's outlines, bearing in mind the need for a strong reason for refusal, and also we'll come on to what prospect there is of the flood defences being removed in due course, but we say there's no prospect at all of that. So I hope that provides some useful context. And I don't know if anybody else wants to add anything.
Thank you. Does the council have any comments to make in relation to the framework? If you feel it really important to say something about paragraph 11 now, feel free, but if not, we will be coming back to that.
I don't understand Mr. Banner's points, and we agree that it's down to the residual risk, and we're not looking at the sequential test, so it is a...
Sorry, could you repeat that again?
Yeah, sorry. So we're not arguing an exception test that the site has failed. The exception test, we're arguing that the residual risk has not been sufficiently considered, and that impacts the delivery of the development.
Right. In light of that, I'm just going to take a quick moment and review my questions. Okay. So if I can just start here with the council. So can it be taken that you no longer defending the sequential test reason for refusal? Does that equate to you accepting that the sequential test is passed? Or do you just think that the failure isn't sufficient to merit refusing the application?
Prior to making the decision, the weight that was afforded the sequential test was greater than about 3 days after I issued the decision, when the Mead inspectorate decision landed. And so at that time, the sort of weight that we gave it was reduced marginally, and the decision was taken that actually in the overall balance, the sequential test was not something that we needed to contest. I won't say we necessarily agree with it, but it's not something that we wanted to split hairs over necessarily.
And in light of that, and given the wording in the framework which intimates that you don't move to the exceptions test, if the sequential test isn't passed, do I need to consider the exceptions test?
You caught me out on that one, she says. I would say no at this moment in time, because the way I see it, we aren't looking at the exception test as part of our reason for refusal. We are just looking at residual, sorry.
If I can just ask a bit further on that, how does that relate to the requirement in the exception test that the development be safe for its lifetime?
Could you just clarify what you are asking?
Is, in your view, is assessing the residual risk, does the residual risk go to the assessment of whether or not a development would be safe for its lifetime?
Yes.
And turning to the appellant, do you have any?
Yes. So
Response.
firstly, Madam, our position is we comply with the sequential test. We set that out in our statement of case, and the council's offered no evidence against that. So the only evidence before you is the sequential test has been complied with. It's not open to you to find otherwise, frankly. So the question then about what happens in relation to the exception test if you haven't complied with the sequential test doesn't arise on the facts of this case. If it were to have arisen, then in the Yatton decision, the inspector considered that the exceptions test considerations remained relevant. You didn't not have regard to whether the development would be safe for its lifetime in a situation where there's a non-fatal failure of the sequential test. And that set out you might want to have a look at paragraph 175 of his decision. Actually 174 and 175. So that's on pages 35 and 36 of the decision. And the inspector says, although as a matter of strict black letter policy, you don't get to the exceptions test if you fail the sequential test, in a situation where you're still having regard to the overall balance and whether there's a strong FUD reason for refusal, the exercise set out in 178 still needs to be taken into account. So it essentially does the 178 process anyway. That aspect of the decision is subject to the High Court challenge. So the bits that we've relied upon earlier are not. That aspect is the subject of a High Court challenge. It was argued in court at the end of January. I was counsel for Persimmon, and we're still waiting for the judgment. And obviously, if it arrives before your decision, I imagine you'd want us to send it to you in case it was of use to you, but who knows? The judge is obviously quite busy. But I say the point doesn't actually arise in our case because there's no evidence before you that we fail the sequential test. And also, you've heard from the council's expert that they accept that we satisfy the exceptions test, and it's considered whether it's described as a exceptions test we get to in policy because we passed a sequential test, or whether it's a proxy as a material consideration in the way that David Prentice saw it in in the Yatton case. But either way, we comply with that. So the only point of issue between us and the council on flood risk, and thus on the whole appeal, is whether, having regard to 181C, not 178, but 181C, the high threshold of a strong reason for refusal, as outlined in the Faversham case, has been met.
Thank you. So, moving on to the wording of the reason for refusal. Can the council explain to me why the flood risk assessment does not sufficiently assess the risk from coastal flooding?
Yeah, I can do that. So the flood risk assessment set out in not much detail, the risk from tidal flooding. Really looked at.
Sorry, could you move the
Yes,
microphone
sorry.
a little
Yeah,
bit
I shall
closer?
do. That's that better.
Thank you.
In not a great lot of detail, the risk from tidal flooding, considering the presence of the defences, and the site is defended from the flood defences, it didn't give any consideration to the prospect of those defences failing, either through a breach, and really through a breach. We accept that data doesn't exist, and therefore we've used the only data that is available to us, which is the Environment Agency's undefended scenario, so that's the defences entirely removed, which show there are significant depths of flooding on the site, up to 2.8 metres at the access. In the absence of any other data, that is what we have to go with. And we have concerns about the deliverability of the development to make it safe for its lifetime with that residual flood risk. As the council had set out before, we think a development is deliverable. We don't believe that the number of units they're proposing is deliverable.
And what would the appellant's
I'm going
response
to deal with
to?
some policy submission points, and then Mr. Murrams and Mr. Butler will come with the technical. So firstly, there does still seem to be some confusion on the council's part, because the formulation safe for its lifetime on account of residual risk is used, and that's confusing the exception test, which is agreed we pass, and 181C, which is about managing residual risks. The safe for its lifetime is part of the exception test, 178B, and that question is answered by reference to the design event, which is a defended scenario. So this is about managing residual risk. Madam, a number of points as to why...
Sorry, can I just ask you to pause for a moment?
Apologies, of course, yes. Sorry. So,
Thank you.
Madam, so a number of points by way of submission, then I promise I'll let you hear from the technical experts. In terms of whether one considers the 178B safe for its lifetime by reference to the absence of sea defences, following points can be made. Firstly, there's no precedent that any of our team are aware of, or that is before the hearing, no precedent for a decision that answers the question, will the development be safe for its lifetime, by reference to an assumption that existing sea defences will be removed. The fiction rather than the fact. No precedent for that. Second point, there's nothing in policy that requires that. One might think if there were a requirement to determine a case based on a fiction, there would be a clear signposting in policy, either PPG or the MPPF. Nothing. Third point, there's no evidence at all of any prospect that the flood defences here will be removed. And as Mr. Myers and Mr. Butler will show you, it's highly unlikely, given that if they were removed, there'd be an awful lot of homes that would be flooded before the water gets to our site. It would be a national scandal. Fourth point, and this is the aspect that actually will help to see, is they're resilient. They are essentially, and I'm probably using lay terms here, shingle stacked up, which means that you can constantly maintain and top it up and supplement, and you can see if there's likely to be a failure because it shifts down towards the sea. So it's quite different from, say, a dam, where if there was suddenly a crack in a dam, there could be a crisis scenario very much quicker. So they are resilient in that sense, and they are planned to be resilient, and you'll hear from the experts what's meant by that. Next point, Madam, is none of the statutory consultees consider this is a good point, as in the Council's reliance on excluding the sea defences. And it's particularly important, I'd suggest, Madam, that the EA, having been reconsulted, at your, for me, it's a very sensible suggestion, reconsulted following the appeal evidence, maintain their position. The Council don't appear to have given the necessary great weight. You'll know statutory consultees, as a matter of law, have to be given great weight. See the Shadwell cases and others. In fact, there's even one from Wealden, a High Court case from Wealden that says that. So the statutory consultees are with us. The Yatton inspector is with us, as you've seen, in terms of paragraph 77, when one's looking at safe for its lifetime. You don't imagine something which isn't going to happen. And I do invite you, Madam, also to think about the consequences, because if the Council's right that one excludes the presence of sea defences, it would be possible to build anything in central London, because you'd exclude the Thames Barrier. You wouldn't get anything built in Chelsea or Westminster or Battersea, City of London, because you'd have to pretend it's all going to be underwater, which would be a frankly absurd way to approach decision-making, yet that does follow from the Council's approach. What the proper approach is, in the context of 181C, which is where we are, is in considering whether, with the residual less likely than the designed event flood risk can be managed, is have regard to the extreme permutation, even though it's essentially there's no prospect of it, as a sensitivity test in understanding how to manage, not avoid, but manage residual risk. And the experts will explain how they have done that and come to the conclusion that that residual risk can be appropriately managed, but it's only as a sensitivity test to see, even in that frankly impossible scenario, what the position would be to inform the management approach, as opposed to the yes, no, go, no go, does permission be granted or not, which is the domain of 178, which it seems it's agreed we're satisfied. And we've heard enough from me, Madam, and I'm going to pass on to the experts to delve into that a bit more deeply.
So I thought I would talk about how we got to where the flood risk, as you rightly point out, the tidal flood risk section of the flood risk assessment is relatively brief. We reviewed the risk at the time, and as you've rightly noted, the site was in flood zone 3, but this is all effectively irrelevant at this point because we've reviewed and mitigated that risk. We reviewed the undefended, it's a 1,000-year undefended event, I believe. The issue is, as Charlie has just mentioned, that for that to occur, the flood defences along the seafront have got to, in their entirety, just disappear. They do not exist anymore at all. On top of that, the site is over 4 miles inland from the front of the sea defences. Between the site and the seafront is Eastbourne. I believe if in that event, 18,000 houses would be underwater, I believe. The Environment Agency have a duty, and they have signed up to hold the line in Eastbourne and keep the defences for the 1 in 200 year design event. So they have committed to maintaining the defences. The likelihood of them being removed, which is the only way that this event would actually happen, is very, very small. So on that basis, we reviewed it. We didn't consider it a significant risk to the site. As we went through, after we submitted this, the Lead Local Flood Authority and the Environment Agency both reviewed this, and neither of them had any issues. You rightly point out that the project has taken, it's about 4 years, as you say. Vast majority of that was discussing internal drainage matters with the LLFA. There was close to no discussion about flood risk, because the Lead Local Flood Authority and tidal flood risks, I should state, the Lead Local Flood Authority and the Environment Agency at no point had any great concern over flood risk from tidal sources. One other point I was going to mention is that the way that this flood, the undefended flooding, is modelled is at the coast. You take the flood event level, and then the consultant has raised it, so it's about roughly 6.5 metres, raised it to 7 for simplicity, and then laid that over the topography of the land and assumed that at that moment the entire area fills up at that moment. Again, this is only going to happen if all of the defences are removed. No, not a breach, as we've discussed, which would be a very, very different scenario. I think that was what I was going to say. Yeah. The likelihood of this event happening is incredibly small, which is why it wasn't included. But we were quite happy. We would have discussed it should it have been raised as a concern. But neither the LLFA or the EA have raised it as a concern at any point through that 4-year process.
Thank you. Do you have any? Oh,
sorry, I was just going to say, I was too polite. I think the key point I want to raise here is it's the key distinction between the defended and the undefended scenarios as well. I'll repeat a lot of what's already been said, but in terms of the defended situation, that is something that within the documents that has been prepared by all parties, including Ardent, it's agreed that the design event for the development design life is acceptable, and that's in paragraph 5.5 of the Ardent report, which I think is a key point. So really what we are focusing on is the impact of this highly unlikely residual risk. Now, sorry, I'll let you catch up. From my experience, a residual risk is something that is potentially likely to happen. It is usually the failure of a defence, a breach, blockage to culverts, etc. Things like that are often caused due to a lack of management and due to a lack of mitigation. When we start talking about the removal of a whole section of flood defences, for me this is where it's slightly stretching the definition, or my understanding, I should say, of the definition of a residual risk. That said, I do appreciate you're in a position that there is no modelling of a breach or a failure, and therefore this comes down to the management of the potential worst case risk. And if we talk about probability, which is what I seem to spend my life doing with flood risk, it's not just looking at a 0.1 annual exceedance probability event in isolation. It's the probability of the complete removal of forgive me if I got the distance wrong, but it's about a 15-kilometre section of flood defences being removed in their entirety, rather than a localised failure. And the way the water behaves between those two things is very different. If you have a failure, you get that rapid inundation of flooding. And again, this is why a residual risk is typically looked at for tidal flooding areas within areas that are close to the breaches themselves, because it's that rapid inundation, that the speed at which the flooding goes from nothing to very deep is what is difficult to manage. And I think it's important to highlight that in the case of this site, we are sort of 4 kilometres plus from the site, that there is suitable warning time. There will be measures in place to enable the management safely to either put measures in place or to evacuate the site and get people out quickly. And worst cases, I think the modelling shows it's about 17 hours. It's the second tidal cycle that is the one that would cause the highest depth. So we're already talking in the region of 6-7 hours plus, which I think is an important point to note when it comes to the management of this residual risk, and given that this is now a separate issue which is agreed from the exception test.
Thank you. Do you have any
Yeah, and sort of
points of
come back on
challenge?
that point. I understand the sort of key point is that the removal of the defences is unlikely, and I accept that complete removal of those defences is unlikely to occur. What we'd usually like to review in these situations is breach modelling data. We don't have that. The appellant could have undertaken a breach model, and that, as Mr. Banner pointed out, that's what we have in London, and that's what we use to inform development, is that breach modelling. There's nothing to say that the breach modelling wouldn't be as bad as the undefended scenario. The only data we have is that undefended scenario, which is why we've used it. If the undefended scenario was less significant at the site, then you could say, well, hang on, maybe we're being a bit dramatic. But it's 2.8 metres of flooding at the access is significant. So if the breach modelling was anywhere close to that, that would be very difficult to manage in terms of keeping residents safe. So I understand the warnings, but you don't know about a breach occurring in the middle of the night. You don't necessarily get that warning to reach the site, because breaches occur sort of when they occur, if you know what I mean. So it's the lack of data which has pushed me to using the undefended scenario rather than the breach data, which I would much rather use. Sorry, I just wanted to add, so the appellant is agreeing that the residual risk needs to be considered. They're not presenting the data to allow that to be done, other than having to use the undefended data.
Is there, given that, I think you're intimating, you were talking about there being 15 kilometres worth of flood defences, 15 miles of flood defences?
15 kilometres, yes. That's part of the shoreline management plan refers to that. And the funding as well, to make sure they're still in place, is tens of millions of pounds.
Is it, in your experience, is it unusual for there not to be widely available breach data?
It's not unusual, no, and it's not unusual for a developer to have to do that. We certainly regularly undertake breach modelling to support developers. And part of the breach modelling, so I don't know what section they're looking at when they refer to the shingle bank, is understanding where a breach could occur that would have the worst case impact on your development, or the wider community. So I know the way the levels behave is complicated in terms of the way the flood risk develops. So a failure directly, at the closest point to the sea may be the one you may think, well, that would be the place to look at, but actually it may be that somewhere along the coast, say further to the north, may have a greater impact in terms of a failure.
Have you anything to?
Yes, I think in terms of, there's a couple of things I'll come back on. I think the first point is the point raised about a breach happening in the middle of the night. I think there are suitable procedures and processes in place nationally, locally, to ensure that risk doesn't happen. There's the Environment Agency's early warning. And again, if we start looking at a failure of the defences, whether that be localised or across the whole reach, it is 18,000 properties at risk that the emergency planners, the Environment Agency, would be responsible for ensuring that warnings are given. And on top of that, I'd also point out that this is a tidal risk. So therefore, increased tidal events are much, much more predictable than a pluvial flood risk or a fluvial flood risk because of the long-term sort of management and prediction that goes with them. So I would say, yes, whilst there is that on a theoretical basis that it might be in the middle of the night, for me, I think there is suitable warning, there's suitable timeframes that mean people can adequately put processes and it can be suitably managed. And this is not a new concept. It's used, as I say, probably globally, but definitely nationally, to manage such risks. With respect to the points about undertaking breach modelling, I think I have caution from experience of this because there are a very wide set of sort of variables that can be considered. Where is the weakest point? What is the weakest point? How is it going to happen? Where do we do it? That it becomes a bit subjective as to who looks at what and where. And equally, I think, again, it would be a more important exercise to undertake if we were in a rapid inundation zone. As I say, this is about managing the risk, not understanding the risk. And I think the management of the risk decreases the further away you are from the defences because you've got, as again, I'm repeating myself here, but you've got that additional warning time that you can implement those procedures. That is it right to model a series of breach defences for a development scheme that is 4 kilometres plus from the point at which flooding may occur? In my view, I don't think that's commensurate with the scale of the development. Additionally, what we are looking at is noting the point about the residual risk. I still feel that even if the defences were to be removed, which I don't agree is the right way, I think it's overly conservative, the site is such that there is still a pedestrian access in and out of the site. In the event that the vehicular access was done, there are still alternative routes that are free from flooding during all of these events. So again, that just demonstrates that how through no changes to the proposed development, there is a management in place. Yes, it's not ideal, but you have to bear in mind that the event we're looking at is so far removed from what we have to do in terms of policy requirements.
It's got three.
And
sorry.
I think you did say this, but just for the absolute avoidance of doubt, in your discussions with the Environment Agency, they did not ask for this work to take
They
place.
have not asked for it, no, correct. Neither have the LLFA in the discussions we've had with them either.
And Madam, that's something which you're legally obliged to give great weight to, applying the legal approach to the position of statutory consultees. Madam, the three policy legal points in light of what the Council said earlier. Firstly, it's wrong to say that paragraph 181C requires the residual risk to be specifically modelled. It doesn't. It's a duty of outcome. Any residual risk can be safely managed. You don't need to put the arrow in the bullseye and say the residual risk is going to be specifically this. Any residual risk can be managed. You model the design event for the purpose of the exception test. That's what's modelled. Building on that, madam, there is no policy requirement anywhere for breach modelling. And if that's wrong, then I'm sure the council will show us which paragraph or which policy document that requirement is in. And thirdly, madam, what you've heard from Mr. Myrams is consistent with the approach of Inspector Prentice, relying on, indeed, on Mr. Myrams' evidence in the Yatton case. Paragraph 183. It might be worth looking at that either now or later, but it's at page 37, where Inspector Prentice says, I consider site locations a key factor. It's some distance from the coast. This is not a site at risk of sudden inundation. And that significantly reduces the risks to people. He does acknowledge in that case that the potential residual risks would not be totally eliminated. They'd be mitigated, i.e. managed. So when you're in 181D, forgive me, I said C, 181D territory, the policy objective is not the avoidance of risk. So the approach you've heard from us is entirely consistent with paragraph 183 of Inspector Prentice.
Firstly, coming back to the council, would you agree that there is not a need to model the residual risk?
I agree there's not a specific need to model a breach, but there is a need to understand what a residual risk is to allow it to be safely managed. If you don't do that in terms of breach, then you're left with looking at the undefended scenario, which we're looking at. I'm a bit confused by that point from the appellant's side, if I'm honest, of they agree that residual risk should be managed, but haven't really set out how that has been done, giving consideration to these flood depths at the site. So for me, the trigger would be, you've got significant flood depths shown in those undefended scenarios. I would prefer to have breach modelling available to be able to do that. It's not as complicated as Mr. Myrams set out. Again, we do it very commonly. It's not a dark art. It's just modelling. I understand there is the access to the north. That is a pedestrian access. If I had an emergency during a flood event, I'd want a bit more than a pedestrian access for a 250 unit development. I don't think that's appropriate. In terms of the Environment Agency's remit on this, I understand that the Environment Agency have commented on this. Emergency planning sits with the council as a such consultee, so that's within their responsibility, which is why it's relevant. I think that's everything I've got to say.
On that point about this, again, it has to be very careful about language. It was said, you asked the question, do you need to model residual risk? And the answer was, you need to understand what a residual risk is. With great respect, that's not actually an answer to the question. You need to know, in orders of magnitude, the nature of what would be dealt with in this extreme and largely hypothetical scenario. It's not the same thing as modelling it. With respect, Mr. Myrams has got some points, I think, of response as well.
Yes, I think the key one here is that there's clearly not agreement as to whether it's needed or not. However, we're in a position that the Ardent report refers to the complete removal of defences. And I think it's key to point out that is it condition 30, or the proposed condition 30, talks about the need for a flood evacuation management plan. Oh, sorry, that's a Yatton condition, sorry. Yes, so for Yatton, sorry, yes. I'll start again. So on Yatton, there was a planning condition, because it's similarities with this scheme, about how to manage the residual risk and how to manage access and egress, etc. And that was agreed as being a condition for reserve matters. Now, we're in a position here with, as I've said, even if we look at the very worst case, i.e. the complete removal of the defences, yes, it's not ideal that there is, it's a pedestrian access at the very peak of the event, but there is still access available to ensure people can move in the event that they have not evacuated or you have not evacuated during that significant warning they've got. And I would propose that this is an appropriate method to deal with this residual risk here, because again, it is showing how we manage the potential risk in this critical, well, not critical, in this, this hypothetical event of a complete removal of the defences, which therefore is showing that we can manage it even in a really conservative and over-the-top assessment. And that negates the need for undertaking breach modelling because, as we said, it's not actually...
It's the worst case scenario, essentially. So if you can be satisfied that as in the Atherton case, because of the location, because of the lack of sudden inundation, etc., all the points that you already have, that a condition of that nature can deal with a worse than worst case scenario, then precisely where the actual residual risk would be is moot, because you're able to manage something that's even worse than that. And that's the key point.
And in reality, if we were to undertake the modelling, the risk would be lower than what we're confident can be addressed within a flood evacuation plan.
Yeah, sorry, I'll come back on the appropriateness of a flood evacuation plan. So my understanding of the Yetton case, which obviously the appellant is keen to draw parallels to, the flood depths are significantly lower. And I think it is, in that case, appropriate that this could be readily managed through a flood evacuation plan. That's something we do. Sorry.
So I don't want to go into the details of the Yatton case, but if we look at an undefended event there, we are talking of depths of around 2 to 2.5 metres. So again, if you remove all the defences for the Yatton one, it's similar to what's been quoted for occurring here.
Fine, apologies. Again, I'm not that familiar with the Yatton case. So sorry, where had I got to? I don't believe a flood and water management plan, a flood evacuation plan is appropriate to manage these depths of flooding, given that they're affecting quite a lot of the properties. Kirsten, you had the number of properties it was affecting, didn't you?
50.
50,
Between 50 and 60.
50 to 60 properties. I know we're repeatedly referring to the access to the north, so my figure 5.2 in the flood risk statement of case, appeal statement, shows that access to be flooded in the undefended scenario. Again, the only data that we have available to consider a residual risk. So that is not necessarily accessible during that worst case event. So the key point we're coming back to is it's not that we don't believe a development is deliverable here, but a development of the quantum shown is not appropriate to manage with a flood and evacuation plan. The appellant has not demonstrated how these flood depths will be managed within the development. I know they say it's unrealistic, but this is all the data that we have available.
I'm not sure there's... Sorry, have you something you wish to say?
I notice, or I see that the appellant submitted the report peer review in March of this year, so quite late in the day. And the way I see it is that it kind of confirms that point, that there is a residual risk, because they recommend that it could be dealt with through a flood evacuation and warning plan. Now, suggesting possibly by, local finished floor level measures and that sort of solution, that's a new explanation. It wasn't in the original case when I assessed it, and it wasn't something that was offered to me with detail. Because you can say flood evacuation and warning plan, but I didn't have details before me when I was making that decision. And what kind of event would we be planning for to deal with? What would be considered a safe refuge? What would the evacuation assumptions be? What happens if the flooding affects the main access? What is the alternative route in and out? A pedestrian route, which I believe goes under an archway, which I believe from local residents floods, or at least is wet, very wet. And how does that, and I come back to how does that planning deal with the lifetime of the development? How do you manage this for 100 years? Rapport have indicated that there is a residual risk that could be dealt with a flood evacuation and warning plan, but I never saw that when I was making my decision. And so this is new evidence as far as I'm concerned, and didn't play a part in my decision-making process. The decision-making process included the evidence that I had at the time, and not a future scenario that could be addressed. They're not minor details. They go to the heart of this outline permission and whether it can be safely granted. I know that we've said that the appellant has said that the undefended scenario is conservative, and we accept that it's conservative, but the residual risk by its very nature and the concern of what happens when flood risk management infrastructure doesn't perform as expected has to be considered. And the potential severity here is substantial. It's not a shallow nuisance flooding. It's the lifetime, it engages the lifetime safety of the site, the access, the egress, the emergency management, and the deliverability of the full quantum of development. And being somewhat shorter of stature, I wouldn't want to be worrying about 2.7 metres if I were living there. And that's just from a personal point of view. And I know I should take personal points of view out of there. But actually, at the end of the day, that's my starting point in many respects, is could I get out of there safely? And possibly not, is my worry. And I think the MPPF supports me in that, in saying that it should be safe. I won't quote paragraphs, I know you know them, but it just seems to me that the appellant has said in their peer review that there is a residual risk that should be dealt with or could be dealt with through a flood evacuation and warning plan. So if there is a residual risk, then in all honesty, we need to address that in another application, because that wasn't presented to me at this stage.
I'll go back first.
Madam, some of those points go to the cost application, which I will deal with separately. Once again, you've heard confusion from the council between the requirements of paragraph 178, exceptional tests, which they have confirmed we meet, and 181D. issues such as safe refuge, the avoidance of impact, are in the context of 178B, which, to repeat, the Council accepts we comply with, the exception test. So saying, though it's been accepted, there will be a residual risk, that's nothing to the point, because 181D is premised on the fact that there may be residual risk, and it asks the question, can it be safely managed? And to reiterate, there was an accepted residual risk in Yatton. Small and dealable with. Small in likelihood, as here. Madam, the other aspect of 181D that is relevant in this context is the word can. You've heard from both the council speakers that we don't have the details of the flood risk management plan. This is new evidence. It said, well, you don't actually have the details now. And nor did the inspector in Yatton. That's what planning conditions are for. NPPF doesn't say that an applicant has to show how in detail the residual risk will be managed. It requires a conclusion that it can be managed. It is possible in principle to manage it. And that's where a negative worded condition, whether it's pre-occupation or pre-commencement, may be a moot point, maybe something for discussion later. But a negative worded condition can ensure that the mischief, whether it's occupation or commencement, doesn't arise until a satisfactory plan is put forward. Provided there's some prospect of that being discharged within the lifetime of the permission in the usual way, negative conditions, then that is entirely at a piece with policy. So the granular details of the precise content of a management plan, which, to repeat, is directed at managing residual risk, not directed at the 187B test, which is separate, because 187B is looking at the design event. That is entirely acceptable. And Ms. Martin, I think you've got a few further points.
Yeah, I just wanted to talk through the proposed plan for the flood evacuation plan. I think it's important to note that figure 5.2 within the Ardent report is very much the worst case flood extent that you will get in that event. I think it's important to note that, again, this is about demonstrating it can be managed, the residual risk, is that, yes, if we look at the very, very worst case, based on this undefended event in the 1,000-year, assuming no defences are in place, there is an increased risk of flooding at the site. However, through a flood evacuation plan, there is suitable, in my view, timings. We're talking hours, not minutes, for evacuation to be sought. And if you look at the access, I referred to a pedestrian access route, also the roundabout to the west of the site. That was at the very limit of the flood extent. So again, that just increases the opportunities for access and egress to be gained, and we're not solely reliant on safe refuge. If anything, and from a personal note, I would always try to avoid that. I would always try and look at access and egress and working with the emergency planners, because again, that just further reinforces the safety, and it removes the risks, and it sort of involves more of the emergency services. And again, it's an important point to note that in this event that we're talking about, so the undefended 1,000-year event, the flooding would already have affected a significant number of properties, and there will already be procedures in place for those areas, I would imagine, as part of that emergency planning. So again, what we are talking about is the risk shown with no defences for the 1,000-year event can be managed, because we're only talking about it goes even further to say it's only a small period of time, and actually access to the north from the roundabout is only affected by probably about 50 metres. So again, it's just reinforcing the point that it can be safely managed, either through pedestrian route or through a vehicular access route for the majority of the timing.
One last point for me, but I do apologise. I do urge you to treat the sort of scaremongering with a degree of caution. That was all dealt with as well by Inspector Prentice at paragraph 98 when he deals with the consequence of flooding. Paragraph 96, where he notes that in the undefended scenario, there was a group of houses that was at risk of flooding. What this requires is an objective analysis based upon policy and not being persuaded by sort of jury speeches, if I may say so.
Can I just ask the appellant to confirm, so the flood risk assessment does not contain a recommendation for any sort of evacuation flood management plan?
Not at present, no, because it was it's proposed to be something that's agreed through condition.
Turning to the council, given your understanding and appreciation of the issue, and your recommendation, your recognition that you are working with what you're working with, do you consider this as an issue which could be addressed through a condition for a flood risk for a management and evacuation plan?
I would still retain my reservations with regards to the quantum of development. And that would be my concern, is in allowing this appeal, we would be accepting that 250 units could be placed on that site without putting any property at risk of flooding. And I'm not going to say for the lifetime, I'm just saying potentially at risk of flooding. As I've said previously, we would accept a lesser amount, and that is something that we would very seriously consider. But 250 units is, in our opinion, too high to be safe.
A couple of points. Once again, there's a misunderstanding of the relevant test. This is about managing, not avoiding risk. I won't repeat what I said already. Secondly, Madam, just to test the council's approach and test the kind of extremity of their position, we don't accept a pre-commencement condition is necessary, although it would be within your gift, subject to the relevant contingent consent to a cramping condition being granted. But assume, for the sake of argument, that it were in pre-commencement terms, so prior to the commencement of development, and then something along the lines of the Atom Condition 30, a flood management and evacuation plan should be submitted and approved in writing by the council. The question then would be whether there is some, as opposed to no, prospect of that condition being discharged in the lifetime of the permission. There may be a debate about what the lifetime of permission is, because I think the council want 18 months for RM rather than the usual period. But whatever the relevant period is, the council would have to persuade you, and indeed its spokespeople would have to be in a position to say, in their professional judgment, that there is no prospect whatsoever of an acceptable management plan being approved before the permission is timed out. And is that really their professional view, one might ask?
Does the council have any other issues in relation to the coastal flooding risk
other
that
issues.
they wish to make?
I just wanted to make a further point on the acceptability of a condition. I think to accept a condition, we have to believe in principle that that condition could be discharged within the context of the development proposals. And I don't have confidence that that could be discharged based on the data before me, and that a flood evacuation plan would be an acceptable way of managing this risk. I know Mr. Banner keeps referring to the specific wording of D. Any residual risk can be safely managed. It doesn't refer to lifetime of the development. I don't think you can reasonably say it's not for the lifetime of the development, because it's for the development. So it has to be safely managed for the lifetime of the development.
Any further comments from the
PPG
appellant on this?
21A, paragraph 009, negative conditions, quote, should not be used where there are no prospects at all of the action in question being performed within the time limit imposed by the Commission. So that's what policy says in terms of the test for if it were to be a negative pre-commencement condition. And as for whether it dealing with the lifetime of the development, again, there's a little bit of a collision between paragraph 178, which is where that language is used, and it's agreed we comply with 178, and 181. But in any event, a management plan can have future proofing built in. It could have review mechanisms built in, and Mr. Myers might want to talk about his own experience of those.
Yes, thanks, Mr. Banner. Yeah, I think that's a very important point. You know, a flood evacuation plan is not a one document. It's not a once in time document. It is something that is considered a live document that will be regularly reviewed for the very purposes of what what's been raised here, is to ensure that it remains relevant for the occupants. And that is something that is part of the process in preparing a flood evacuation plan. It is not purely a report to secure planning. It is something that is meant to be there for the development throughout its design life, to ensure that the residual risk, as it changes and as guidance changes and as climate change changes, because these things are subject to change, we don't know what they are, but that is exactly why these flood evacuation plans are live working documents that are undertaken with review from the local authority, emergency planners, and sometimes the emergency services as well, to ensure that there's this coordinated response. So just to confirm, it's not a once document that then fits, it is regularly reviewed.
Correct me if I'm wrong, the suggested conditions before me do not include a condition for a flood risk management plan, or do they?
They don't, Madam. I think they've come, those are the council's conditions which we've commented on, but we're happy to accept a condition of appropriate format, should you think it's necessary. The Yatton decision has a template for that.
Given the potential coverage of that condition that you're talking about, I think it would probably be helpful if we did have something to discuss as a draft.
Yes.
At lunchtime. Appreciate there's not an awful lot of time, but do you think, as the appellants, you would be able to come up with a draft of a condition over lunchtime that could then be circulated for the council, and you could have a look at that sort of quite prior to our discussion of conditions? Simply because,
Yes.
with you talking about things like review mechanisms and the like,
Yes.
I feel that it is a condition that the content of it would actually need to be discussed in the room
Yes, absolutely.
rather
I
than
mean,
being left.
Just to be clear, the prospect of such a condition was flagged in our evidence at 4.4 of Mr. Marham's document. That, as I said, a useful template, it needs some tweaking because it refers to a particular access, but is Yatton condition 30, which we could probably take as a starting point and modify. I think our position would be a preoccupation condition is sufficient, but we would consent to a pre-commencement condition should you think that was truly necessary to make the rent acceptable. You know, we'd rather have a pre-commencement condition than no permission, but we think the proportionate trigger is occupation, so the preliminary works can be undertaken. But that's a matter of a condition session, obviously.
Can I just quick?
Yeah, I just want to add on that. Yeah, we've just been through condition 30, so in principle we're happy with the wording, but I feel it would be appropriate to be as a pre-commencement condition, given the impact on the development, rather than an occupation. We can.
Okay, so
That's an appropriate draft.
we'll add Yatton condition 30 to the list of conditions that we're going to discuss, subject to tweaks.
Just as Mr. Banner said, need to change that. Shine his elm, but details.
Right, does anyone have any final comments they wish to make in relation to this specific point? In that case then, I think if we could just take a short comfort break until midday, and the hearing is adjourned until midday. It is noon and the hearing is resumed. Before we just get back to the main issue, there's a query from a member of the public, so I'm just going to address that first. Yeah, feel free.
Apologies, because I arrived late, so I wasn't aware of the formalities. But I'm a resident who lives directly in front of the North Passage that leads up to this site.
Sorry, can I just pause you? Can I have your name,
Oh,
please?
sorry, it's Karen Chapman.
Sorry.
Karen Chapman.
And is there anything that you would like to say to the hearing?
It's about the flooding issues. So I appreciate there's lots of documentation and all the rest of it, but we'll live here. We've had 5 years. Our house is slightly elevated. We have a large residential houses all the way around, and all the water comes down from those other houses into our houses. And we've got drainage, large drainage to the front, which is actually in the front of that public right-of-way. So we have issues of water coming down. They're suggesting that if there needs to be emergency access for their flooding field to come up, well, that access does flood. It also floods to the right, which is on the dual carriageway. At this moment, there is a little bit of water that does stop cars. It is quite deep. And that is their access, their supposed access to the field on the dual carriageway. The ground is sodden often. It's the reason why it's the levels, it's marshland. So I know we can talk about reports and all the rest of it. I see what I see every day. You know, and when it gets heavy running, it is thick in our garden. So you've got things coming from the north. Forget the coastal floodplains. It's what's coming from the other sides that's also impacting these fields, which should be addressed. Thank you.
Thank you very much. Turning back to the council's reason for refusal, it also refers to risks from fluvial flooding as well. Is that also one of the residual risks that you consider hasn't been fully addressed?
No, it's not. So I think the reference there is that the flood zones refer to both fluvial and coastal flood risk.
Again, if you don't mind, just for everyone can hear you, if you can come to the table, and if I could have your name, please.
Hello, my name is Christine Hanson. I'm a local resident. I'm also a West Ham Parish Councillor, sorry. I would like to support the residents' concerns. West Ham Parish Council owns a stretch of land between Bluebell Barn Way and the new development which is now known as Brickkiln Way. It's known locally as the pylon field because it has a large pylon in it. That field runs downhill from north to south towards the pedestrian access point to the development. That field is completely sodden throughout the winter months, such that if you're walking in wellies, the water is still up to your ankles, even though it's grassed and regularly cut. Last year, Southern Water put in extensive drainage servicing the new site at Brickhiln Way that goes down past the resident's house. Throughout the winter, that development site is incredibly waterlogged, particularly at the bottom end, adjacent to the railway line. That land acts as a sponge and soaks up water. Once there is development on that site, I would be really concerned that the runoff would affect the railway line and we would lose our railway connection between Eastbourne and Hastings. I know that's not, I've spoken to the Wealden and they said that wasn't part of their concern, but as a local resident, I would be much more concerned about that risk than about any risk from coastal flooding. Thank you.
Thank you. I do have a few questions about surface water flooding that I will come on to with the parties in due course. Apologies, I'm going to ask you that question again just because I like my flow. So, can the council please confirm, do they consider that there is a residual risk from fluvial flooding as well?
No, we don't consider there's a residual risk from fluvial flooding.
And the reason for refusal also refers to the flood risk assessment not sufficiently addressing future climate change scenarios. Can you elaborate on that, please?
So it comes down to that, the undefended scenario. So it came from originally the updated, what's called NAFRA 2, the National Flood Risk Assessment data shows a increased climate change extent covering quite a lot of the site, and it's drilling down into that because that's the undefended risk, which gives that, it's that future climate change. So not just looking at the flood zones, but looking at the climate change as well.
And is there anything further to say on that that hasn't already been covered by the previous discussion? Does the appellant have any comments?
Only to note that I think it does follow from that as between us and the council, the entire appeal turns on the defended, undefended point and their suggestion that there should have been breach modelling. Just for the record, Madam, because this may be relevant to the costs issue, so I think we need to ventilate it. It is our position, you may want to ask the council to confirm this, that at no stage during the current of the application did the council ask for breach modelling. And I'd like to, through you, give the council an opportunity to respond to that as a matter of fact, because that's maybe relevant to costs.
On that point, firstly, obviously, the Environment Agency did not object to this application. Did you have any discussions with the Environment Agency before the application was refused, arguably, saying something different to what they had said? And as part of that, was breach modelling discussed with the Environment Agency? Did you ask the appellant to carry that out?
No, we didn't discuss anything further with the Environment Agency. No, we didn't discuss breach modelling with them either, and it wasn't raised. And no, not specifically in my knowledge, and I say that on a personal level, did I discuss breach modelling, but the case was in part run by another colleague who's not here, so I can't confirm 100% that he didn't ask at some point. But to be honest, for my position, no, I didn't ask for anything specifically in terms of breach modelling, although we did discuss and talk about flooding.
Thank you. So, Madam, it does appear to be the Council's case that essentially the single reason on which you should refuse permission on appeal is we haven't provided something which we weren't asked for. And Mr. Mimes just wanted to add a couple of points as well, actually.
I did, yes. I've just gone back through all the consultation responses, and in particular those from the Environment Agency. It is worth noting that the Environment Agency raised the point we're discussing now about access and egress, hazards, safety. They raised that in a consultation response of the 22nd of September 2022. That was part of one of their earlier objections to the scheme, and then following further works undertaken by HOP and JBA with the detailed modelling, the Environment Agency actually removed this as a reason for objection, as you can see from their now confirmed position of no objection. So again, it feels that we've, as the appellant team, conversations have been had with the Environment Agency on this, and they remain happy that the approach is suitable. And again, there is no request for breach modelling.
Thank you. Turning to the residual risks that were looked at in the flood risk assessment, the statement of case briefly sets out the residual risks, specifically considering the effects of a blockage on the Willingdon Sewer Railway culvert. In paragraph 5.4 also refers to residual risks being limited to exceedance events above the design, storm and failure of the sewer network. Can you direct me to, is there a section in the flood risk assessment that assesses these residual risks in any more detail?
I don't believe there is.
I was just going to say, whilst we're just double checking that, it's worth noting that at that point, agreement had been in place that the defended event, coastal flooding, didn't reach the site, and that's something that's been reiterated within the Ardent report, and that's why the focus was more on what was considered to be the key mechanisms of flooding to the site, which were, as you point out, it was the surface water flooding from the north, which we've also now heard about, and also the fluvial flooding being caused as a result of issues and stresses from the existing culvert, which is why the focus was on those two elements.
As you were saying, the residual risks were considered to be, most of the report was considering surface water flood risk at the site. So the residual risks were the ditches overflowing and surface water not being managed within the site. So it was about how water can flow around the buildings down to the Willingdon levels at the south without impacting the buildings.
Does the Council have any comments on regarding the residual flood risks that were considered in the FRA? As part of the appeal process, I did ask for the Environment Agency to be reconsulted, and I believe both parties have seen their comments. Starting with the appellant, do you have any comment on that updated response beyond the fact that it reiterates their position in principle? One thing I did notice in that comment was they referred to updated advice on finished floor levels and the need for the proposal to include a 600mm freeboard if development were to be in flood zones 2 and 3. I appreciate the point of the development is that were it to go ahead, it would not happen in 2 and 3. But is there this reference to updated advice about finished floor levels? Is that something that are you aware of what that advice is to the council, and would that have any bearing on this decision?
I noted it within their consultation response, but floor levels, I suspect, would be considered at a later date in the reserve matters, and so it wouldn't necessarily have any impact on this decision in bringing forward a development. The appellant may counter that and say, no, 600mm will be impossible, but I don't think so.
And the appellant?
No, it reflects the latest guidance. It shows the change in guidance during the process, so no, there's no issues with 600mm from this side.
No, sorry. The 600mm reference was about the freeboard, which
Yes.
I'm assuming wouldn't have a bearing here. I'm talking
None
about.
at all.
I'm simply talking about the fact that they refer to updated advice on finished floor levels. Is there something else around that? Is there anything else relevant? Right.
No.
Just to add for completeness, madam, not that we suggest it's necessary, but the Yatton permission has at 29 where that was a case where finished floor levels were quite important to the points of dispute, and for the avoidance of doubt, there was a condition saying that the details in RM should include details of finished floor levels with specifications. So in the event, we don't think that it's necessary, but in the event here you thought anything turned on that, it might be possible to fashion a condition making clear for the avoidance of doubt that the RM details should include details of finished floor levels. I would have thought that probably is part of the RM anyway, but it's really spelling out for the avoidance of doubt. It's condition 29.
Thank you. Excuse me. Moving slightly away, before I do that, do either of the parties have any final comments they wish to make in respect of flood risk, starting with the council?
I think it's just one point in reference to the Environment Agency's comments. We understand the Environment Agency made their petition with no objection. The Environment Agency don't have responsibility in relation to emergency planning. That sits with the council, so they wouldn't specifically comment on. They may make comment on, but they wouldn't object on the grounds of an absence of safe access and egress from a development. That sits with the council.
And any final flood risk comments from the appellant?
Well, only that last comment is demonstrably wrong, because they did specifically and expressly deal with this very point, and then having turned their mind to it further, decided that they didn't wish to object. I mean, this is plainly within the EA's remit, and therefore plainly engages the well-established principle that the views of statutory consultees should be given great weight. See the Shadwell case and see the Ashdown Forest versus Wealdon case.
Thank you. Slightly off the main issue, but since we're talking about flood risk and drainage, I think we might as well just keep going with it. The comments from the two ladies who have spoken this morning reiterated comments that are made by a number of the interested parties, which refer to flooding events in the area, such as the collapse of boundary walls, sewer flooding following heavy rainfall. Is the council aware of any such floods, and have any investigations been carried out into these?
Investigations-wise, probably no, in my understanding, but I am aware that there has been flooding. It's identified in our SFRA 2022. I haven't checked the 2025, but I suspect it's much the same. And there are 3 instances of flooding noted for the site in that respect.
And obviously, the point of this development is to ensure that it in itself makes appropriate provision for drainage and that it doesn't increase flood risk elsewhere. Do you think that any potential off-site effects from surface water from the north specifically have been covered?
The LLFA were consulted, and along with, I gather, a lot of work between the appellant and the LLFA, their objections were removed, saying that they believe that surface water could be managed for the site. So,
thank you. Again, does the appellant have any comment in relation to? And another comment raised by an interested party was relating to the principle of the pumping station and the attenuation tanks and where they should be located relative to the wetland conservation area. Is there any reason in, good practice effectiveness that though that infrastructure could not be put in that location?
To my understanding, no attenuation tanks nor the foul treatment, foul pumping station are within the conservation area.
Is there any reason they couldn't be sited in proximity to it?
Particularly the foul pumping station is relatively flexible in where it can be located. The attenuation basins do need to be at the bottom of the hill, but there is flexibility in both how they're landscaped and located.
Does the council have any comment on that? And turning to the council, starting with the council again, are you satisfied? There's been a lot of concern raised about the capacity of the foul sewerage network. Are you satisfied that can be appropriately addressed?
we have an ongoing Grampian condition that is applied, which, based on the Old Orchard appeal, recently determined for elsewhere in the district, there is a capability of ensuring that the appellant can deliver either a drainage position that is acceptable to us and to the foul water services. So, yes, I think it can be addressed, basically.
Apologies that I haven't committed all of your conditions to memory. Is that the condition that you have suggested? Thank you. And does the appellant have any comment on this? I think that concludes the questions that I wanted to ask on the main issues. Is there anything that any of the parties would like to raise in relation to any of the main issues? Excellent, thank you all very much. Given the time and the fact that we have just had a break, and I do have relatively few questions on other matters, so I think is everyone okay with keeping going for a bit longer? Excellent. So these are generally questions for both parties in response to comments raised by interested parties. I will come to you as I see fit. Firstly, starting with the council, are you satisfied that there would not be a severe or adverse effect on the operation of the A22 or the surrounding highway network?
Yes.
Are the council satisfied that any future occupiers of the site would have the ability to access services and facilities by means other than the private car? It appears that it would be likely there would be increased use of the West M22 public right-of-way as a result of the proposed development. What is the council's view on the effect that would have on the living conditions of surrounding occupiers of that public right-of-way?
It's not something I considered at an earlier date, to be frank, and I have other sites where it's managed through the design of the reserved matters. So I think it's something that we could consider at a reserved matter stage, if needs be.
This could be, and this is partly why I asked for the map of the definitive map earlier, the West M22 is referred to in the Section 106 agreement as being restoned. Which public right-of-way is this? Where does it go? So that public right-of-way does go through the appeal site. It's not the public right-of-way that runs from the appeal site and then up towards Ditton's Road past what I think is Pylons Field.
Honestly, I'd have to get my mapping out and check. Have you got it there?
It was going, my interpretation of one of the representations from the interested parties seemed to be suggesting that there would be an increased use of the public right-of-way that runs from, forgive me, I don't have the street names to hand, bear with me. Yeah, there's the public right-of-way that the access comes from Rother Avenue. It's next to Stour Close. And then that runs up through Bluebell Barn. And it was my reading of one of the interested party comments that there would be an increased use of this that would have an adverse effect on their living conditions.
And it's hard to see how that could really be anything more than de minimis in practice, because it's not bringing the right-of-way any closer to the properties. It's about intensity of use, and to be at such a to be at a level where that would have a material planning consequence. One would be thinking about, you know, multiple people per minute or something. Otherwise, it would simply not be noticeable. There's this fairly good rule of thumb in terms of vehicle movements. Of sort of one additional vehicle per minute is unlikely to be noticeable. And when we talk about people, very hard to see how that could really have any material planning consequence, let alone one that would overcome the tilted balance.
I would agree.
Of course, there's benefits. I mean, part of the use, the part of that is it's active travel, which obviously is something which is being positively encouraged by the planning system.
Thank you. On a similar note, so if I can just ask if you can come to the table, please. Thank you.
Do you want me to introduce myself again? The path that goes across the estate, the development site, and then goes up through Bluebell Way, through up to the top of Bluebell Barn, would be the only way people on that estate could access public transport. There is a bus service that goes along Dittons Road into Pelgate and then into town, or in the opposite direction along Dittons Road down Friday Street and into town through Langley. If you're talking about people from the estate using public transport, there is no public transport that goes along Golden Jubilee Way, so there would be no opportunity for putting a bus stop on Golden Jubilee Way, even if that was a suitable highways issue. There is a paved footpath that goes from Rother Drive up to the beginning of that field that's called the Pylon Field, but then there is no paved footpath, it's all grass. It's used predominantly for dog walking, and it is incredibly muddy in the winter and whenever it's been raining. But like I say, if there was anybody on that estate who wanted to use public transport, they would have to use that path up and go through the estate or across the muddy field of the Pylon Field. And you would get an awful lot of people traipsing through that estate, which is the old Red Barn Farm development.
Any further comment from this?
Just to sort of go further with my lady there, we do have a tremendous amount of pedestrians that walk across our front. I live on Stour Close, as I said, directly onto the right of access public path off Rother Avenue. And Rother Avenue actually winds up through the development. It's actually quite a long walk up to the top. and that's the only way to get up to those bus stops. So you're having a lot of people with the only of this new development to come through the front of either going through a muddy field or winding up through residential, quiet residential, to get up to the top line, which has already had a tremendous amount of new houses put all the way along the top. So you've got traffic problems all along the top of Ditton's Road, and then that filters down back to the roundabout. Then if they put a proposed new roundabout a little bit further up, then you've got traffic issues coming on. So you've got traffic problems plus pedestrian issues. And the only right of access really for most people who want to walk will be through the residential, which will impact us. Thank you.
Thank you. To the council, is there any evidence of antisocial behaviour in the area that would be made worse as a result of this development?
Not that I am aware of. We're quite a low crime district. In regard to the bus issue that has been raised, there is a bus service contribution included within the Section 106 that can be used to extend bus service. And that might be an option in terms of resolving everybody walking through the estate.
Any comment from the appellant on either of those points? Of course.
West Ham Parish Council maintains a children's play area in Cherwell Close, which is just to the east of Rother Drive. I have lost count of the number of times we've had to remove burnt-out play equipment and benches and bins and replace them. There is consistent vandalism all along that section of wooded area that runs from Rother Avenue. There's a pedestrian access around the back of Cherwell Close that goes up to Arran Way, and there's continuous vandalism there. As Parish Council, we get reports from the PCO regularly about that.
Any comments from either of the parties in response to those comments? Thank you. Can the risks from noise pollution be adequately addressed to the council?
There are a series of conditions that have been applied by the environmental health or recommended by the environmental health officer to address issues, and subsequent, so long as those are approved, then I suspect that means they can be addressed. So they are controlled and will be controlled via the condition.
Can any adverse effects from air pollution be adequately addressed?
The same applies. in that the environmental health officer has applied a condition.
Is it necessary to secure biodiversity net gain on the site? And if so, is there a mechanism before me to secure this?
As I understand it, it's the application was pre-BNG.
Another comment that was raised by interested parties referred to the site operating as a functional extension to Shine Water Park, which I believe is to the east. Is that something that the council considered?
No, because as far as I'm able to think about it, it's divided by the train track. You can't actually get to it without going over the railways, which I couldn't advocate.
We agree, and also apart from the right of way, it's private land. So.
Sorry, excuse me. It's not helpful if there's other people talking in the room. Yes.
Whether it's relevant, I'm a runner. I use the park that you're actually talking about. A lot of us do actually run because it's you can run through right of way. Yes, you can't go through to the next field, but we come across the top and then down into it. So it's actually used by quite a lot of people as access around to the park runs. Lost my train of thought. It's like a huge conservation area down there. So it is used. Maybe people don't see it, but it's only because I'm a resident and we see it all the time. And the council might not be aware of that. So I appreciate you can't jump to the next section, but that is a lake. It's all, and there it just overflows. All that wildlife and all the rest of it overflows into that particular field. So it is used by a lot of people, including. Well, I'll just leave it on that point. Thank you.
Thank you. Is the council satisfied that appropriate provision can be made for water supply? The application was accompanied by an energy statement, I believe, and a question has been made of, does that energy statement take account of the energy demands of any pumping station associated with the development, and if it doesn't, should it? Starting with the council.
In terms, I haven't reviewed it in that respect, so I couldn't comment.
think we're just, Madam, but if you look at page 33 of the officer report, there's reference to the energy statement, which we're still trying to dig out. And the focus of that is on the appropriate inclusion of renewable energy and associated energy efficiency measures for the dwellings to deal with relevant policy relating to that matter. I'm not convinced that there would be an applicable policy to how one would power pumping stations. It would seem to me that the relevant policies are likely to be directed at energy efficiency and renewable measures for houses, which is why the officer report says what it says. But that's as far as I can take it without seeing the document. I can't confess it wasn't top of my reading list last night.
And from the council.
Yeah, I would agree. The pumping station would be serviced by the statutory provider, however they manage their electricity or that sort of thing. We are specifically looking, when we do sustainability and energy, at renewable resources and the fact that the council adopted a climate change position a number of years ago. So we would be looking for air source heat pumps and the like, rather than whether a pumping station keeps going.
Thank you. In the interest of party representations, a potential other use for the site related to transportation and logistics has been put forward. Do the parties have any comment on this? And while I appreciate it's agreed that the emerging local plan is of very little weight, is that an issue that has come up? Are you aware if that has been considered through the emerging local plan?
I'm not aware of anything in terms of the emerging local plan, no.
And do you have any comments about the potential for another use of the site as it would relate to this appeal?
No, no further comments.
This particular use is acceptable. It matters not. It's not uncommon for there to be multiple potential acceptable uses of one site, but if this particular use is acceptable, then there's no question of alternatives being something that could overcome the presumption in paragraph 11.
Thank you. The council provided to me its habitats regulations assessments, and when I've gone through that, the officer report appeared to only refer to one of the sites, whereas the appropriate assessment goes on to consider quite a few of them. I'm not going to start listing all the names out. Do I have sufficient information before me for all of those areas to allow me to carry out an appropriate assessment where it's necessary?
As an authority, we always assess all three particular areas, but the conclusion was for this, the Pevensey Levels area and the Ramsar was the particular one. So yes, I believe you have all the information you need.
And does the appellant have any comment on that?
Agree with this.
The comments from interested parties raised considerable concern about the increased demand that would be placed on social infrastructure, such as schools and healthcare facilities, as a result of the proposal. Do the parties have any comments as to whether these are matters that should be addressed through this planning application?
We collect SIL as an authority, And so contributions can be taken and used in that respect.
And turn to the appellant.
No comments.
We have touched on this already today, and both parties have included in their statements how the proposal should be assessed under paragraph 11D of the National Planning Policy Framework. Is there anything either of the parties wishes to add to their statements or their comments that they've made today in relation to that?
Just for the avoidance of doubt, step one, I'd suggest, is to ask, are there flood-related strong reasons for refusal within the meaning of paragraph 11D1, and you have our case on the approach to that, see Faversham. We say there's no conflict with paragraph 181 or indeed 178 of the framework, but even if there were, even if that's wrong, it plainly doesn't meet the high standard of a strong reason for refusal having regard to Faversham. If we're wrong about that, if there's a strong reason for refusal, there's a strong reason for refusal. One goes no further. If there isn't a strong reason for refusal, then all the other aspects of the case fall to be considered in the context of paragraph 11D2, and it doesn't appear to be a matter of dispute between us and the council that in that scenario, if we get to 11D2, the adverse impacts don't significantly outweigh the benefits. Therefore, the framework points in favour of permission, and to the extent that there's any non-accordance with the development plan, the framework's support is a material consideration that indicates allowing the appeal.
And the council?
Our position hasn't changed.
Thank you. Are there any more comments anyone would like to? Ms. Chapman.
I'm sorry, I should have wrote everything down. I'm thinking as you made a comment about the schools and facilities. We moved, as I said, 5 years ago to the area, and we were living in the North Harbour. When we've moved in, we couldn't get into the Stonecross doctors. They were full. We reapproached Polegate. They were also full. So we had to go back to the North Harbour, and which they actually kept us on. I was at the doctors this morning, which was the reason I was late getting here, because I have to take a 15-minute journey from my house to go to my doctor and then get back out again. So facilities, and like I said, we've had more houses since we moved here, all along Dittons Road that follows down into Rattle Road. So it's got to be a consideration. Thank you.
Thank you. Of course.
This is a completely different point. I just wonder what's happening with the high voltage electric cable that goes diagonally across the site, more or less over the site of the cycle path. I know that the reason that the field north of the site, known as the pylon field, cannot be built on and was given to the parish council by the Red Barn developers was because they couldn't build under that high voltage power. It then goes from the Bluebell field diagonally across the development site and then across the Willingdon level. I've not seen any plans to put it underground.
I'm turning to parties on that. Just before you go though, can I just double check? How do you spell your surname?
Sorry?
How do you spell your surname?
Oh, Hanson, like the cement company.
Thank you. the appellant, has that been factored into when you've been looking at, but you know, apologies, does the indicative layout consider the position of the pylon and cables?
Yes.
And was the council satisfied with the way that had been considered?
Yes, but if I could address the doctor's surgery
Yes.
issue. The council as an authority accepts that there is a position where the provision of health care is constrained in the district, and as an authority we are actively working to deliver and develop doctors' surgeries around the district. We've got one currently in the pipeline in Mayfield and another one in Polegate. So it is something that the authority takes seriously, and it is something that the new Polegate facility would be able to support.
In case it helps out on the pylons, the design and access statement 4.5.2, the various references, but that's probably the most relevant. Don't need to turn it up now, but for your note.
Sorry, I missed that last sentence.
4.5.2, I don't think you need to turn it up now, but that expressly evidences that they're taking into account the pylons as a factor.
Great, thank you. So, turning back to the council, do you have any last comments you wish to make in respect of the appeal?
I don't, thank you.
And does the appellant have any last comments they wish to make? Okay, it is 1 p.m. We have conditions and the obligation to get through. How are people? Would people like to stop for their lunch? Or
The census here is probably looking at Nicholas Scrooge. I think probably crack on, but unless you've got a burning hunger, depends how long you anticipate we will be on that session. But
I wouldn't want to make any promises. The council, are you happy to carry on? So for the members of the public, we will be the council have submitted a draft list of conditions. This does not prejudice the council's case in any way, shape or form, and their responses to my questions also does not prejudice the case that they have very clearly made today. I will be asking the views of parties on those conditions, and if any of you have anything you wish to add, please indicate that you wish to do so. However, this is all without prejudice to everything that has been discussed previously today. In the event that I do allow the appeal, the decision will include a section setting out why any conditions have been imposed and why they meet the tests for such conditions. I may make changes to the suggested wording of conditions in the interests of clarity and enforceability. If you can just bear with me while I get the list open. Or not. Okay. Any comments on condition 1? Condition 2. Can I ask the council, why have the time limits been reduced for both submission of reserved matters and implementation of the permission, with particular reference to is 18 months reasonable for a development of this scale? And given the timescales that would be involved in complying with other conditions, such as condition 16, which requires monitoring between autumn and spring?
Given the position of our housing land supply, the condition is reduced in that we are seeking to bring forward development as quickly as we can. So we do think it's reasonable at this stage. And it's been tested at numerous appeals.
Bring it forward any quicker.
And does the appellant have any view?
Yeah, I mean, the first part, there are two shorter time limits. There's the first part for submitting RM and the second part implementing. And for the first part, I mean, 18 months is very short. I've not seen such a short period myself in circumstances where the site's got to be marketed and sold, given Mr. Hobbs is not himself going to build this out. There are now statutory extensions of time for judicial review, but they are particularly, they're not for the whole duration of the JR period. They are 1 year in the High Court. So if somebody were to bring a judicial review challenge, given how long the High Court cases take, well over a year now, that could potentially reduce the time limit to about a year, give or take. There are various Grampian or conditions proposed by the council too. So I question whether 18 months is really an appropriate truncation. The concern about the council has about land supply and delivery could be addressed by leaving B as it is. So once reserve matters has been granted, then a shorter period of time to then implement the reserve matters, harder to object to, because by that stage there would be somebody on board, they would have got reserve matters approval and every reason why they should get underway. And the appellant's got enough incentive to take this forward if permission was to be granted, because there won't be a return for his time and investment, all the stress, etc., until he finds a buyer. So don't need a shorter time limit to encourage him to do what's necessary to get a house builder on board.
Would you consider anything less than the standard time limit to be reasonable?
I've not seen any evidential case that the case has been made. I mean, the 5-year supply situation can't be enough in itself, otherwise that would be a standard condition up and down most of the country. And you might again see something stronger in policy than the only hint is in paragraph 81 in the framework, which falls far short of saying where there's a 5-year supply shortfall, you should get half, not just less, but half. And we're happy to leave it to your judgment, madam, if you think some midpoint is appropriate, but we'd say that limb B, i.e. once reserve matters have been granted the time limit for implementation, that should be the focus of a shorter time limit, rather than getting RM, because you never know the unknowns. I mean, we've had nutrient neutrality, we've had water neutrality, all the sort of curveballs that have come and affected the development industry and meant RM can't be discharged in other places. And there's a danger otherwise of the law of the unforeseen getting in the way.
Thank you. We did discuss approved plans at the beginning of the day, so that would be added to condition 3. Condition 4, is there sufficient certainty, given that it includes a tailpiece, allowing parts of the condition to be dispensed with? Starting with the council.
The condition itself is suggested by environmental health officer, and therefore we bow to his experience.
Any comments from the appellant?
My concern is that the condition requires inclusion of all of the measures which are there, when it seems to me that to a certain extent they should be sequential, in that not all of them is necessarily going to need to be provided. When you don't need a remediation scheme, for instance, if the earlier stages haven't identified any problems. And it seems to me it would be easier and more pragmatic if the condition was not one condition, but a perhaps even 4 conditions, saying that if the remediation scheme is required, for instance, after the site investigation has taken place, then it should be provided at that stage. My concern is that the condition as it's drafted requires all those things to be submitted, where, for instance, if remediation is not required, that element is not required either, and would only be required depending on what had happened in parts 1 and 2.
Does the council have any comment on that?
I think I'd agree with Mr. Stevens on that point. It's not very well worded. And like you said, once the investigation, basically the investigation report will then determine whether any remediation scheme's necessary. So I probably think you can have maybe parts A and B as a standalone, C as a standalone, and then D and E as potentially a standalone condition. But they either need to be sequentially phased, as Mr. Stevens said, or they do need to be broken up.
As there are going to be, be waiting for the Section 106 to be completed, there are some other conditions to discuss. And given that this is a very standard issue, I think it would be perfectly appropriate if the parties could agree wording between themselves and then submit it to me after the hearing, because I said none of this is contentious. Thank you. Condition 5, if I can ask the council, the emissions mitigation assessment carried out with the guidance, is there, or are you aware of, are those mitigation measures likely to include anything that would have an impact on the appearance and layout of the scheme? Or is it a different kind of mitigation that it does?
I believe that condition relates to a different kind of mitigation in terms of air quality, as opposed to actually, say, noise mitigation from the A road.
Anything from the appellant?
I think that's right. The report is about the emissions from the development itself, as opposed to the other way around.
Thank you. Condition 6, the Code of Construction Practice. What would be the aim of public engagement as part of this condition, given that the site is quite well separated from the surrounding residential properties and there's control, the aspects of the development are controlled, hours of operation are controlled? What would be expected by public engagement? And would that be reasonable?
I think it would be, and I think it would just be to notify probably those properties closest to the site along that northern boundary, and just in terms of when works are starting, construction hours, and just to make them aware of that.
The appellant?
Don't have any particular problem with the condition.
Thank you. Condition 7. Would this condition be effective were habitat enhancements to be required, given that it's prior to commencement of development, and I think it's reasonable to assume that habitat enhancement could involve aspects that would relate to the landscaping of the site?
Sorry, can you just repeat your question on that, just so I'm clear?
Well, it's simply that when the supporting ecological information, it refers to going through the licensing process, and it refers to habitat enhancements as being a potential mitigation that would be required.
Right.
Were that to be the case, is prior to commencement a reasonable trigger, because that could theoretically affect the layout of the site, the landscaping that was included in the site.
The point being, should it be prior to submission of RM, to inform the RM?
I appreciate I'm about to undo my own argument here. It's, sort of simply, how do these two things potentially work together? If in your experience, does this process tend to work well in your area? Are developers in the area sufficiently well versed that they are capable of they know what's coming down the road for them, so they address it appropriately?
In my experience, yes. I think it's quite a straightforward process, and they either go down the licensing route, or we get a simple letter or email confirmation from Natural England that there's nothing that needs addressing via a license. So I've never experienced any issues with kind of this condition.
And is it reasonable to have a condition that requires another authority to grant a licence?
My understanding, yes. Like I said, we've used it and it works, but I've never kind of had any issues with it.
Any views from the appellant?
I think, to be fair, that the condition does require that the council be shown a copy of the licence which is granted by Natural England, which is a different process than the council themselves, granting a licence. So it works that way. You get the licence from Natural England and then you show it to the local authority. I don't think there's a conflict there.
It's not obliging Natural England to do anything, is it?
Right, thank you. Condition 8. Firstly, is it reasonable for a condition to require consultation with the County Highway Authority?
To be honest, I think we've got standard worded conditions for highways, and it's just a carryover from a long time ago. To be honest, I think it can just be simplified to local planning authority, and obviously in any event we would formally consult with them anyway.
And in light of the discussion this morning, is it necessary for part 1 of the condition to be there about the A22, given that the details of the roundabout would now be an approved plan?
If I may, this condition does somewhat duplicate the requirements of Schedule 10 in the Section 106 agreement, which requires, prior to commencement of development, us to have entered into a Section 278 agreement for the off-site highways and a Section 38 agreement for the on-site, which would require the technical details to have been addressed.
That being the case, would the council be satisfied with this being an issue addressed through the Section 106 rather than a condition?
I don't believe so. If it's covered in the 106, I haven't got that in front of me, but yeah, I would be satisfied that if it's dealt with thoroughly via the 106, it doesn't need to be duplicated as a condition.
That's the matter I mentioned this morning when we got to conditions. That's exactly the point.
Might be, Madam, in due course, that if that creates a number, you could slot in the flood risk to that number and you preserve the rest of the numbering. Otherwise, the whole numbering's messed up. So, very convenient.
Thank you. Condition 9, is it necessary to control all of these matters through the planning system, or are these not matters for the Highway Authority?
I was only going to say, well, that there's also potential conflict with some of the terms of Condition 27 about the construction of access roads to adoptable standard. So we certainly don't need both conditions, even if we need one of them.
Likely just standard conditions, I would imagine, suggested by the Highway Authority that we obviously regularly use on sites. Obviously, it's within your gift if you go ahead and grant the appeal, whether it's necessary or not.
In that case, then I'll just skip on to 27 and look at it at the same time. Well, again, is condition 27 necessary?
I don't think so.
And the council?
Yeah, I don't think it's necessary.
Condition 10. Yeah, just is the appellant happy with the wording of condition 10?
Yeah, I think we're okay with that.
Condition 11 talks about a management and maintenance plan for the entire drainage system. Is that sufficiently precise? Is that foul water? Is it surface water?
That should be just surface water, so I think it can be made clear in there.
Just for the avoidance of doubt, stranger things have happened. Probably worth adding for the development. There's no, so the entire drainage system for the development or serving, something like that, so it's not later misunderstood as applying further afield.
I've got nothing to add about comment about condition 12. Does the appellant have any comments on condition 13? Condition 14. is there sufficient clarity around what before preparation of ground levels for development would mean as a trigger?
It's something that we use regularly, but I will be guided by you if you wish to amend it. That's
Just
we would be agreeable. Yeah.
what would it mean? It's just because obviously, you know, there are other triggers on other conditions. I think, for example, and I'm not going to be able to find an example of one in it. Thank you. Yeah, just is this a term that you regularly use and that's clearly understood, and you can clearly convey that when people come to discharge their conditions?
It's a term we regularly use, and I think it's just to allow, obviously, site clearance works and bits like that, but would obviously prevent maybe a spade going in the ground as such. It's not quite prior. I suppose you could argue it's maybe prior to commencement then, but I think it's to allow site set up and bits like that beforehand.
Okay, thank you.
I think prior to commencement is a precise term. What's used here really isn't. It's much more difficult to determine the phrase before preparation of ground levels for development than it is commencement of development. And in many ways, preparation of ground levels for development is indeed a commencement to development anyway.
I appreciate I'm putting you on the spot. Do you have an alternative trigger that could be used?
Prior to commencement of development.
That appears to be potentially adding a more stringent condition than the one the council has suggested. I'm going to assume the council's happy with that. Thank you. Again, condition 15, I have no comments. Condition 16, it's a purely technical procedural question. How would this actually work in practice? Because it says that the reserve matters should be accompanied by a surface water drainage scheme and that the surface water drainage scheme should be submitted and approved. So you would have a separate approval process working inside the reserved matters. And just, you know, procedurally, how would you make that? And indeed, is that necessary? You know, I get the submission of the details as part of the reserved matters to inform them, but why would it need to be approved separately?
Suspect the rationale for that is that there's at least some doubt as to whether reserve matters actually includes surface water drainage. I mean, it can be part of layout, but there have been some cases looking at what's meant by the reserve matters and what sorts of things fall within them and what sorts of things fall without them. I suspect the intention of 16 is to sort of, for the avoidance of doubt, these matters have to be approved. I think that must be what's behind it. I didn't write the condition. That's my. I'm involved in some litigation at the moment over what is caught by the standard reserve matters conditions and what is not. So I suspect that's what it's directed at.
No, I appreciate the belt and braces approach to having details of how the surface water is going to work as part of the reserve matter. You know, I get the point of the approach. I'm just something wondering that as this is worded, does it mean that you have to have a separate approval process within the reserve matters? Or can it simply be that the reserve matters are accompanied by those details, and then those details would just naturally, they would be approved as part of the reserve matters. They don't need a separate approval process, is kind of my point.
Yeah, that's right. I think that's the point. Maybe it's not worded clearly enough, but yes, the idea is the reserve matters would be accompanied by and informed by surface water drainage scheme. Obviously, we'd consult penalty levels and the LLFA, and obviously, hopefully, then approve the drainage scheme through the reserve matters without needing a separate condition discharge application later on.
Can I suggest we take that one away and add it to the list of ones we might rework or have a look at clarifying? Because I think I agree with the intention, but getting the drafting in a way that doesn't cause problems later is a good idea.
Council agreeable to that? I do apologise that I'm being so pedantic about your conditions. I've had it done to me, and yeah, it's not fun. Condition 17. This is a very long and very complex condition. Firstly, is it necessary for that level of detail to be within the condition? Is it sufficient, despite its length, is it sufficiently precise? And is it reasonable and necessary and appropriate for overheating to also be getting factored in as part of the condition?
I'll keep it short. It's the first time I'm seeing these conditions. So I would imagine, again, this is taken probably verbatim from the Environmental Health's consultation response. It is way too long, overly prescriptive, and can be much shorter, and I would imagine the appellant will be happy that we'll probably work through this condition as well and make it much more concise.
Thank you.
To the council again, is condition 18 necessary, given that much of the information that's required here would be covered by landscaping as a reserve matter?
Again, maybe one we can look at definitely shortening. I think it's just to try and ensure, again, that the reserve matters is informed by sufficient detail, but actually, you know, if we get a standard landscaping plan with the reserve matters, a lot of this detail can be secured at the reserve matters stage via condition if necessary.
Turn to the appellant.
Yeah, I agree with that, and perhaps the council might like to consider whether it's necessary at all, as opposed to just rewording.
Is that a matter I can also leave you both to discuss?
Yeah, that's fine.
Condition 19, is this necessary? Is that not a matter that would just be considered as part of layout?
Yeah, again, I think it's probably superfluous. We can remove that.
I agree.
Condition 20, similarly, would cycle parking not come under layout appearance?
Yes, yeah.
Condition 21, is the trigger appropriate? Is it possible that details of water, energy efficiency, renewable energy, are those not matters that are likely to inform the, you know, for example, are solar panels not likely to inform the appearance of the dwelling? Is this not a matter that, not that I'm wishing to make suggestions to you all, but is this not another issue that should be considered as part of the reserved matters?
Potentially, I think maybe a safer solution would be prior to above slab level, because it's not just talking to, obviously, air source heat pumps, solar panels, but obviously sustainable construction methods, potential sort of water and energy efficient measures within the home. Obviously, it could be considered via the reserve matters submission, but by putting this condition on, we ensure we're getting those details.
And does the appellant have any comments?
I think it could be part of the reserved matters application, and in a lot of senses it's relevant to that, although I understand where the council are coming from in terms of requiring those details. I think there are other means of doing so.
Other means of doing so being?
Well, through the reserved matters. I mean,
Would the council have any issue with that?
No, but obviously I think we'd still like the condition there, so maybe the reserve matters application shall include details of X,
Yeah.
Y and Z.
fine with me.
Again, 22, is this trigger appropriate, you know, given that the findings of that acoustic report could inform where those houses should actually all sit in relation to each other? You know,
It seems to me the condition effectively requires the preparation of 250 separate reports on each heat pump to establish its relationship with the adjoining buildings, which I'm sure the council can't have meant. But yes, it obviously affects the way in which the layout works. If one of the considerations about siting of dwellings is where each of the heat pumps is going to be, it's just part of the overall layout of the disposition of dwellings. I'm concerned at the way the condition is worded, as if it requires a separate report on the acoustics related to each heat pump.
comment from the council?
I think one we can probably discuss together and maybe look at wording on.
Condition 24, is it necessary to have a condition requiring it to be proved that the surface water has been implemented? You know, is the standard, you know, the development shall be carried out in accordance with the approved details, is that not enough?
Sorry, what condition are we on? I'm looking at...
Sorry, 24.
Oh, 20, sorry, I was on the 23, the one before. Yeah, I think that's a standard condition that we would expect.
Any comment from the appellant?
It's not a condition that I've seen before. The works are required to be carried out by other conditions. I don't see the necessity for this at all if the work is done in accordance with the conditions that are imposed. I don't see that it adds anything.
I suppose the only other option could be, just thinking on the spot, is that we could include within the surface water drainage condition that prior to first use of the drainage system, evidence shall be supplied to demonstrate X, Y, and Z.
That is one of the conditions that you are discussing, I believe, surface water. In the event that you do not agree and you wish to have, you know, specific bits of conditions where you don't agree, assuming that you've all made your points here, I'm happy to have alternatives submitted as well, if that's easier. Got no comments down to, and as we discussed earlier, a condition based on the Yatton condition. I think you mentioned there was some wording.
Myron just very kindly tweak the Yatton condition to refer to.
Thank you. My first question with this is it likely that any flood resilience measures would involve place of safety?
No, is the easy answer. The proposal is for access and egress, so emergency responses to get in and out.
Right, so there would, you don't anticipate a circumstance where finished floor levels and place of safety would form part of that scheme?
That would only be in the event that residents chose not to follow the procedures, which obviously is out of anyone's control.
Right, does the council have any view on whether they would expect a place of safety to form part of any flood resilience measures?
My view is that we would need a place of safe refuge. We don't have enough evidence that the site can be accessed or egressed in the event of a flood. So I think it's bold to say that at this point.
Sorry, could you move the microphone over a bit? Sorry.
It's bold to make that at that point. It could be something, you know, if unless further evidence is submitted to demonstrate that it's not required.
If I can jump in, what we want to do is avoid sort of promoting safe refuge, because in line with the guidance of managing thing, it is all around trying to get people out for the duration of the flood event, and that's why I've put the wording in. I know your point, but if you wanted to, the other option is it looks at a safe refuge on a higher level, but obviously that's not the preferred option. So again, it would be trying to use the flood evacuation plan to manage that and not promote that for residents to use.
Yeah, I understand the intention. The concern is that it is required and it's not provided, if that makes sense. And I don't think it's clear that it's not required.
We can always add a sentence in. That's not a problem.
Yeah, fine.
And again, this is, as I will confess, I did not read the Yatton condition on the break. Who would be regularly reviewing the document?
It'd be something to be undertaken with the management company, who would be taking it on and then having discussions with the local authority to ensure it remained acceptable. I would point out this goes further than the Yatton condition because there was no time limit put on that.
Thank you. Does the council have any views on that as a condition?
So the question we're putting forward is how would that be managed by the council on the council's end? That's not something that is done regularly, I assume, for other developments. So it would be new. The condition doesn't require it, so I think Simon's just making a good point that it could be opened up to the council if needed. So I don't think it's a point of contention. It's just so otherwise I don't think I have any comments on the condition.
If it was placing a requirement on the management company, is that something that should be either specifically said in the condition or incorporated into the obligation that sets out the responsibilities of the management company? Again, I'm just thinking in practical terms of this actually working down the line for everyone.
How I've dealt with this before, and I welcome comments from the other side, is to actually write it into the document itself. So there's a paragraph in there that says the validity, the assumptions. So therefore, when this gets handed over to residents and if the properties were to change hands, again, it's clear then that everybody would have that there. And in one case I'm working on recently, it's actually the residents that have prompted the management company to update it because they've noticed that it's lapsed.
Any comment from the council?
Yeah, that sounds sensible to me.
Again, can that wording be tweaked with the others? Moving on to the obligation, and I've got really very few questions about this, you'll all be thrilled to hear. I have been provided with the unilateral undertaking. Parties have confirmed this morning that that's been agreed. The council has also given me its civil compliance statement, which sets out how they consider the obligation meets the relevant tests, and I have no questions about that. Again, these are very picky, making sure that it all actually works in practice questions. You're happy that it's how you normally work. That's a perfectly good answer. The para 613 of the obligation includes prior written notice of a number of points in the occupation of the development. It's related to the private dwelling units, and that includes the self-building custom house, custom plots. I appreciate it's not a huge number of dwellings, but obviously they all count to the percentage. Keeping track of when those units are being occupied, is that something that you could reasonably be expecting the developer to do? You know, I'm just thinking, I said, I know it's a small number, but these things do happen. Would it be more straightforward if the trigger did just relate to market dwellings?
I think it depends on how the self-build, custom build comes forward. So if the self-build comes forward as something that the developer itself is going to deliver with modification, I think it can be included in that respect. With regards to the self-build, I think that will be controlled because the likelihood is that you're going to end up getting an additional planning application for that stage, because that's not an that's how I interpret it. So we could potentially monitor it with a reserved, with the full application coming in for the individual plot. So I don't think it's unreasonable to ask them to do it, but if it needs to be addressed, then I'm sure between Nicola and I we can do something.
It is more an issue for the council being able to, because, you know, I've possibly watched too much grand designs, you know.
You never watch too much grand design.
Sorry?
You can never watch too much grand design.
Yeah, but, you know, they got their planning permission, they started building, and 6 years later, they're not living in the house, and that's the trigger. As I said, but if you're happy with it.
I mean, what we would say is that there is a limited time for marketing the products, and that's 12 months unless we agree an extension to it. So at that point, it falls back to the developer. So it would then be included within their monitoring.
From experience of other clients on other sites, the self-build and custom build, which is a relatively small percentage proportion of the private dwellings, tend to come forward a lot slower than the market housing. So you tend to have hit your 75% occupation without them, if that assists.
Yes, completely. The obligation also allows 3 months for the disposal of the affordable housing units to a registered provider. Is that long enough in the council's experience?
Our affordable housing team have reviewed the Section 106 and are happy with it.
Thank you.
If that provision is any longer, it can cause issues with RPs getting funding to actually take the sites. So it is the one thing which I end up getting asked to vary the most often if it exceeds the 3-month period.
Thank you very much. Schedule 4 on page 49 and the definition of open space scheme on page 14, they refer to a scheme approved by planning conditions, but I didn't notice a condition requiring open space. I can't see that the conditions require the details of implementation, management, maintenance of open space. Am I missing something?
This may be as a result of a slight communication gap between conditions and Section 106 drafting, which is one of the reasons why we haven't signed this yet. I think we can either impose the condition or we can require the pre-commencement submission and approval of the scheme in the 106. And I am more than happy to draft it either way, depending on council's preference.
Does the council have a preference?
In general, we include it within the Section 106, but I'm happy to go either way.
Yeah, we'll do it through the 106 and not via a condition.
That's absolutely fine. If you can all take that away and address it, that's fine.
Of course.
Again, just for my avoidance of doubt, the reference in Schedule 10, Part 2 on page 60, the Dittons Road footway works are the same as the off-site highway works that we discussed at the start of the day. Yes.
So, despite the County Council not being a party to this agreement, they were very closely involved in its drafting. So this particular schedule has been reviewed very, very heavily by the County Council solicitor. I was already on it, that's why I couldn't find it. So the off-site highways works to be secured by the Section 278 agreement include, so the Dittons Road footway is putting a pavement on, I believe, that particular side. Underneath it, the enhancement of the public right-of-way, Westham 22, to reach the public transport, that would be the improvements of the bit that I understand crossed the muddy field. Joining that unpaved bit, because they are outside of the site, and therefore would be in the 278 agreement. The Part 3 works and the references to public right-of-way, turn the page, 21B is the section of the public right-of-way that goes through the site itself, if that assists.
Yes, thank you. So going on from that though, the plan in Appendix 2, it refers to Section 106 plans, but it looks like it's the same red line plan as in Appendix 1. Is that correct? Or have I missed something?
So this is where we're going to have to get pedantic, and it probably would have helped if I'd printed these bigger. But there are some, so the Section 106 red line plan includes the highways round. So if you note, it includes Golden Jubilee Way, where the junction is going to be. All of that is not within the ownership of the client. And there is a tiny little bit at the top, which kind of just sticks out. It also does not include that bit. So the Section 106 plan in Schedule 2 is the land within which most of the development is going to happen. So that's the bit that we're binding by the agreement, because that's the bit which will be enforceable against in the ownership of the owners. The red line planning application plan, which is the plan in Schedule 1, includes third-party land, which is primarily highways land. So it's not bound by the provisions of the 106 agreement. That's the distinction between the two.
And again, just for my clarity, it's not necessary for that Section 106 land to include, or for any of them to include, let me just see, Ditton's Way or anywhere like that. It's not necessary for that to be in it.
No, the 278 agreement will cover the works within the highways, so.
Thank you very much.
I do have one point which arises out of our previous discussion from one pedant to another. Depending on where we get to on the management company and the flood risk management plan, we may need to just tweak what we need the objects of the management company to include in the definition on page 12. But that will be a minor drafting point that I can pick up.
Again, I feel that that's an issue that, as long as it's made very obvious to me what you've done and where, I'm happy for you all to take that away. So, moving on to I think this is probably a sensible time to sort out the timing for the submission of all of these. When do the parties think would be a reasonable time that they would be able to have, both the Section 106 completed and the condition wording agreed?
My general standard for this is to ask for 2 weeks, just in case something goes wrong in execution or sealing or anything like that. This is actually a fairly straightforward 106 agreement from an ownership perspective, but considering we've got the conditions to amend and some minor drafting tweaks that will need to go back and forward a bit, I think 2 weeks is reasonable.
For everyone's ease, and since there's a bank holiday, shall we say Friday the 15th? Close of play Friday the 15th, is that okay for everyone? You're right. Are there any more points or issues anyone wishes to make in relation of conditions of the obligation? Thank you. So moving on to costs, I think you indicated earlier, Mr. Banner, you could submit those in writing.
Yes, I will. I I don't need beyond the end of this week because I'm going to do it whilst it's all in my head. And there's nothing worse than putting something off and then coming back to it. So if you're content to give me till Friday, and I'll try and get it to you before then.
Yes, and then I'll subsequently close the hearing in writing. Is it still the council's position that they do not wish to make an application for costs? Thank you. So moving on to the site visit arrangements, I think the parties were going to indicate locations where they wanted me to view the site. Have you been able to do that? Or have you got places you just want to tell me to go and look at? That's fine too. Well, the appellant is just, if you want to keep discussing that, is there anywhere that any members of the public would like me to specifically go and look at when I'm carrying out my site visit? Please.
Considering that they're mainly looking at the north end, which, as I said, does affect us, and I know there's flooding on that area, so particularly the right-of-way path that leads down, and as you follow that down, and as you go along to your left, your right-hand side, where would be access, all of that area does get quite a lot of flooding. It rolls down, so So
again, just so that I'm.
So I'm always looking at the field. So you got the right-of-way archway, and you will go through that section. You'll immediately come onto the field. It sort of rolls down, and they want to put houses all the way around. But particularly on the right-hand side, you'll see as you'll go down. You'll feel it as you come through. So that is the main sections. As I said, we get a tremendous amount of wildlife. Sorry, I'm going off that. Conservation is a really big thing because we get huge amounts of animals coming off that field into our development. And we are concerned about that. But anyway, flooding, that is the area to go to.
And is there anywhere in the area, any of the other locations that you've referred to today, are there any of them you think I should specifically go and look at?
I'd be very happy to meet you or have our parish clerk meet you and walk you through the estate around Dittons Road and what you're calling the muddy field.
I don't think it's necessary for me to be accompanied by anyone,
Right.
As it is all, I would be viewing from public rights away and from public areas in the surrounding area.
I think you'll get a good impression of what the development will look like, what impact it will have if you walk from Rotherway up through the field. Let me just get my Google Maps up. Keeps going back to sorry about this.
Is it going from the public right away?
So going from the public right of way,
and then is that just basically then following that public right away to Dittons Road?
You come onto Rotherway, and then there's a public right of way that goes diagonally to Bluebell Barn, which is the name of a little road, and zigzags up the field to Hamble Road. So from the entrance to the site, the footpath entrance, you come onto Rother Avenue, you turn left, you go along a footpath which goes up the hill under the pylon and comes out on Hamble Road.
Yep, yep. Thank you.
To see the flood defences, I mean, they're pretty much the same the whole way along, but there's a car park called Prince's Car Park, which is near Crumbles Pond. I believe that is also where the final outfall for the whole levels area is as well. Not that there's much to see of it because it's below water and below the beach, but it's a good place to see the extent of the defences. We'd also recommend seeing, I assume you'll go to the site, but when you access it, you'll walk through the pedestrian tunnel under the old railway. I recommend seeing that just so you can see that it is reasonable size.
Do you want to explain, Tom? When
Sorry, can we just back up a little sec? Because Prince's Car Park on Google Maps is not helping me at all.
Fort Fun, the one that you named Fort Fun, it's a car park right next to Fort Fun.
Yes.
That's Fort with a T. Sorry.
Yes. Yes, I think so.
Yes.
Right, we can- Right, yeah.
And then I think in terms of, can you just explain to the inspector what you explained to Mr. Stevens in terms of what to take from the site visit when you see the flood defences, what that shows?
Yeah, so I guess the reason for going is we've worked on plenty of sites where breach modelling is an issue and the Environment Agency will provide that. And these are generally around a harbour that's got a harbour gate, for example. The breach would obviously be if the gate failed, there's an obvious breach and you can model that. The point of looking at this is that there's not a vulnerable feature in a way or an element that can easily be, that can fail. So the point is partly to look at quite the scale of the defences that are there, but also to view quite how robust they are and their maintainability. They're not going anywhere, I think, is the put simply.
Is there anything the council would like to add to what I should be looking at if I go to the flood defences?
No, but do consideration that the defences will need to be upgraded over 100 years for climate change, and we don't know what that will look like.
I may slightly disagree on that point because we do know what we have modelled future climate change events, so we do know what that looks like, and the Environment Agency have committed to upgrading it, improving the existing. You are saying about the form of improving the.
I don't think we need to go any further than this one. I think the point is that I'm going to go and see what is the nature of these flood defences, and it's just anything that either of you think I should be looking at, I'm not going to be looking at.
Exactly. The key point is it's not one physical structure that would have a potential to fail. It's essentially a big stash of stones that goes on for a very, very long way that can be topped up and is topped up over time.
And in terms of the actual site itself, are there any particular points or features on the actual site itself that anyone would want me to go and look at? Obviously, it's quite a large site, so I just want to make sure I don't miss anything.
Quite a large amount of quite similar visually land, so it's allow quite a while to walk around it, but there's no particular point that you need to see.
And the council? Thank you very much. Right, I do not think there are any other points or issues that we need to address today. Is that everyone else's opinion? In which case, I would just like to thank you all very much for your contributions and the civil manner with which you've all conducted yourself. And the hearing is adjourned until I have the costs rebuttal. Thank you all very much.